release the garnishment that was at issue for the objection. That was e-filed today.
Okay. All right. So do you understand that and agree to that, Mr. Perez?
I am in agreement with those statements, sir. I agree. Yes, Your Honor.
So again, you have to pay the $2,089.35 by June 24th. And so long as you make that payment, plaintiff's counsel is going to file a satisfaction of judgment. And then the garnishment has been released. He filed that this morning so that your wages will not be garnished or your bank account.
Thank you, Your Honor.
Understand that?
Yes,
Okay.
Your Honor.
Anything else that I need to add, Mr. Johnson?
Nothing for me, Your Honor, no.
Your
Anything
Honor,
else? Yeah.
If I may, I'm working on that Garn release right now. And if he needs a copy for his employer, other than us mailing it, he can stop in and get one.
Thank
So do
you.
you understand that? That'll speed up the process then, okay?
I do, Your Honor. Thank you very much. I appreciate your guys' help.
So you can call the court. I'm gonna have to sign that, obviously.
Judge
you
is signed by a clerk. You don't have to.
Okay, good.
It's just the Garn release. Yeah.
Right. Okay, perfect. So you can come up there and get it now. Thank you.
Thank you.
All right. Thanks, Mr. Johnson. Have a good day, everybody. Thanks.
Thank you.
Thank
Source
you.
Realty Management versus Megan Galoro, 2504376.
Good morning.
Okay. Good morning.
Good morning, Your Honor. Attorney Carrie Zanon on behalf of plaintiff.
Good morning.
And your name, ma'am?
Megan Galoro.
Any resolution on this one, Ms. Zanon?
I do believe that we have a resolution. However, can we have an adjourn date? Maybe like give us 60 days discovery. I just need to speak with my client and then I will reach back out to the defendant. We've talked about resolution in a payment plan, Judge.
Okay, let me go ahead and do that. Give me your P number again, if you would, Ms. Zanon.
67390, Your Honor.
And Ms. Galoro, you understand what she means by discovery?
Yes.
All right, so I'll give everybody 60 days. So we're gonna make this April, we'll make it May the 24th of 26. I'm not gonna order ADR. Nobody demanded a jury. I'm going to give you guys a trial date in early July. I'll put down 1/2 hour for trial. And witnesses are due by May. May the 1st, I'll make it. May the 1st. You don't have to file a trial brief. If you choose to, it has to be filed and exchanged not later than 7 days before the trial date. We're going to put everything right in here in the pretrial order that will be mailed to you, but I'll give you a trial date right now. No motions on the date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. So why don't you give me a trial date, Jen, and I'll go from there.
July 13th at 10:30.
What day of the week is that?
It's a Monday.
Good. You said at 10:30?
10:30. Yes, Judge.
July 13th at 10:30 will be the trial date.
Thank you, Judge.
Anything else anybody needs to bring up on this one?
No, Your Honor.
All right. Thank you very much. Have a great day. Any
You too.
questions, Ms. Galoro?
So do we have to go to trial if this gets resolved before then?
We do not.
No.
Oh,
I'm just setting a trial date if it isn't resolved, then we're going to go to trial.
Okay, understood. Thank you.
Okay. Good luck to you.
Thank you very much.
Here you go, Sadie. Just leave that there. LVMV funding versus Rachel Snyder, 2505163.
Your Honor, there's actually a companion file as well, if you want to call that one at the same time, ending in 65.
Yeah, I have 2505163, and I also have 2505165, LVMV versus Rachel Schneider.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673, on behalf of plaintiff.
David Lady, P269.
For Ms. Snyder.
I'm here on behalf of defendant. Can you hear me, Judge?
I can't hear
Can you hear me?
not a word, and I can't see you.
Can you hear me now, Judge?
Not very well. I can hear you, but not very well. I need you to start your video first.
I'm having trouble with my video. I don't know why it's just your court that I have that problem, but I do. But I can hear you and hear Mr. Groen. Mr. Groen,
Gotta have you speak louder, get closer to the device,
I have.
turn your volume up. Working? Are you out of Las Vegas?
The attorney of record is, Your Honor. This is just appearance counsel for Jocelyn.
Yeah, I've just never had him in here before, I don't think. David Lady is his name?
That's correct, Your Honor.
Nobody can hear me, huh? I could hear Mr. Groen
I mean, I
earlier.
can hear you okay, but not really. I don't want to have to strain too much. Where are you at? Where are you at right now?
At my home in Onstead. I work out of my home.
You can't start your video from the bottom left-hand corner of the screen?
No.
Judge, I was gonna say, on my end, it shows his video has started, so I'm wondering if he's got a camera issue.
All right, let me just ask you guys this. Are you close to resolution on this at all?
Your Honor, the defendant is working with a debt settlement company and we actually sent me offer on one of the two that I think we're halfway close on one, but I have not had any correspondence regarding the companion file. So pretty much like the former case you just called, we're just looking for 60 days discovery, and we're hoping prior to us even having to file a motion for summary, we'll get these resolved.
I agree with that, Your Honor, and Mr. Groen.
Okay, hang on one second, guys. Let me just, I never consult, these rise out of two separate debts, is that it?
That's correct, Your Honor. Two separate credit cards.
All right, so I'm gonna do. What's your P number, Mr. Lady?
P 26968.
Oh my God, you've been around a while.
I have my 50th anniversary coming up next month, Your Honor.
Well, congratulations to you.
Thank you.
Your Honor, that explains the camera issue.
Listen,
I
I get it. I was thinking that the whole time because I know how I am, and he's got a few years.
Sorry, that
secretary's been working on
might
the
have been
problem.
inappropriate. I
I was gonna
apologize.
fire my secretary, but it's my wife, so I can't do that. So bear with me.
I got it. Okay. All right. Look, I'm just going to prepare two separate orders here. We'll send them out. I'm going to make them 1/2 hour for trial. Jennifer, I'm going to do the same thing as I did on the last one. Witness list due May the 1st. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. Discovery's open until May the 24th. No motions on the date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. And again, I put this in every order and I don't say it a lot. All motions and responses, as well as trial briefs, have to be accompanied by a second copy. But I guess that's a little bit obsolete too now, the way everything's being done. So I will go ahead and send these out, and I'm going to just do the same thing. Give me the same trial dates.
July 13th at 10:30.
July 13th at 10:30 will be the trial date on both of these cases, okay? And I'm putting down 1/2 hour. So we're just going to basically do the same thing here on these, Sadie. We'll just mirror them. I only filled out. Anything else, Mr. Lady?
No, Your Honor, thank you.
Mr. Groen, anything else?
Not on these, Your Honor. Appreciate
Well,
it.
congratulations to you, Mr. Lady. When is your 50 years actually? Is it November?
Yes, but they're having a
Okay.
luncheon in May in Plymouth, I think.
Well, congratulations. That's a long time.
Yeah.
Have a great day.
Thank
We'll see you guys later. Thank you very much.
Thank you, Your Honor.
Credit acceptance versus Sarah Case Shoup, 2505167.
Good morning, Your Honor. Cezanne Barda, P65425, on behalf of Credit Acceptance.
All right, ma'am. Your name, please.
Yes, good morning, Your Honor. Sarah Kelly Shoup.
Okay.
This is
So,
resolved, Your Honor.
say that again.
This is resolved.
Oh, good. Tell me.
Ms. Shoup has agreed to pay $1,950 on or before July 24th, 2026. That's going to be in the form of a conditional dismissal. I've advised her that I would put those terms on the record, and Your Honor can ask her if I have authority to sign her name to that conditional dismissal. I believe she's going to give me that authority, and we will submit that, and then she'll get a copy. If she wants to dispute anything in there, she can at that time.
So do you understand what he just said, ma'am? He's telling me you're going to pay $1,950 on or before July 24, 26. This will be in the form of a conditional dismissal. The case will be dismissed at this time. If you do not pay that amount on or before July 24th of 26, it will convert to a judgment. And then they'll have the opportunity to execute on the judgment, garnish wages, etc. Do you understand all that?
Yes, I do, Your Honor.
You agree to those terms?
Yes, I do.
Does Mr. Barta have your permission to sign your name to that document?
Yes, he does.
Do you have any questions for me at all?
I do not. Thank you.
All right. Anything else, Mr. Barta?
No, sir, that's it.
Have a great day. What looks different about you? You getting better looking, or what is it?
No, I think I'm getting, my hairline is really far back. That's what's happening.
Oh, come on. All right. Have a great day. Take
All
care.
right, thanks. You too.
I appreciated your comment on that one too. I got to tell you, that was perfect.
Have a good day.
You too. Okay, what do I have now here? I've got, let's see, a citation. Deborah Lee Bolin. And then I'm going to go back over to the Hamptons after this. People against Deborah Lee Bolin, 26F245663. Okay. Good morning, officer. Your name?
Morning, Your Honor. Local David Wolfson, Flat Rock Police. Right to the podium, man.
And your name, ma'am?
Deborah Lee Bolin.
I believe we started this hearing and then you had not been notified appropriately, so I granted an adjournment. And today is the date scheduled for hearing. The charge is driving without due care and caution. I have a question for you. Does she, and I think you told me yes, that somebody was hurt. Was somebody hurt in the accident besides her?
No, but the other vehicle both vehicles were completely disabled.
Okay.
Completely totaled.
All right. So she has
identity fraud, 2 counts of forgery and a theft, and we're going to go forward with sentence today. Is that accurately stated? Oh, no, wait, we can't go forward with sentencing today because we have a victim.
Right.
All right, so we're going to set it for 30 days-ish. I'm just going to go ahead and change the caption here. Everything else is scribbled out, so this won't much matter. To Roger B. Gardner. Mr. Gardner, how old are you?
60.
How far did you go in school?
10th grade.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Prozac.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes.
If you enter a plea of guilty to this charge, we're going to set this case for sentencing. I've represented to your attorney that my inclination is to sentence you to 6 months in prison consecutive to the time that you're already doing. I will, though, if you want to pay the restitution, I'll let you out as soon as you pay the restitution. But I know that financially presents a problem, but that's what I'm going to do. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the, no, we don't have a signature? Boy, we're just, don't. We're not getting much done on the form today. Let's try again.
We were making a change to it. I expected it to come back to me, Judge, and
That's all right.
didn't make it back to me. Which was the title. Help me understand what we're talking
So now we have a signature on the second page, above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Madden before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes.
You're going to enter a plea of guilty to one count of identity fraud. That's a fourth-degree felony punishable by up to 18 months in prison. We have 2 counts of forgery, 1 count of theft. Those are all fifth-degree felonies punishable by up to 12 months in prison, a $2,500 fine. This also carries with it an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If it can, you have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about April 19th of 2025 in the city of Mason, Warren County, Ohio, Roger Gardner cashed a stolen check using another person's identity. This was in the amount of $3,994 at LCNB Bank.
Anything on those facts, Mr. Madden?
Nothing on the facts, Your Honor.
Mr. Gardner, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes.
Do you understand the rights you're giving up by entering your plea?
Yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. We're going to set this case for sentencing, and we're not going to order a PSI, so do a no PSI compliance so that that helps. And we'll come back, I don't know, anytime after 30 days, whatever, and just so we can get the victim notified. Anything else we need to do today?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, that's all.
Go back to penitentiary.
Yeah, and then I'll bring it back.
I had to set the date.
Okay.
I'll get you.
I don't have a problem, ma'am. If you want to reduce it to a 1-pointer, I don't care what it is. Moses, the speed limit is what, 25, right? Okay.
I'm sorry.
That's correct, Your Honor. She was on Seneca. And an eyewitness, residents, I don't think I'm gonna read.
No. I don't need you to do that. I'm just asking if you want to offer her a 30 and a 25.
I have no problem. I have no issue.
That would be 1 point
Of course.
if you want to plead to them. If you don't, we're going to have the hearing, but if you lose this, it's 2 points.
And that's what they said that was the cause of the accident then, right? Because I didn't have the stop sign, the other boy ran the stop sign.
I'm just telling you that you're charged with driving without due care and caution. You can pursue.
If I could just interject so I can shed some light for her. The eyewitness observed the other vehicle stop at the stop sign, make a left-hand turn. However, on Seneca, she was traveling south at an above speed limit rate of speed. He approximated in the 40s, where she would be impossible for her to stop without hitting something if they turned in front of her. Which is her speed was so high, as he turned, she reached him, T-boned him, and he was pushed up onto the lawn where he was less than 25 feet from a home.
Okay, so please listen, Ms. Wilson. I'm not here to quarrel with you.
I understand.
I'm just trying to help you.
Yeah, I agree.
If you want to take 5 over, he's willing to offer it. No, wait, I want you to listen. Don't just please listen. You don't have to do that. If you want to go to the hearing, I'll listen to everything. You might win, you might lose. If you win, there's no points, no fines. If you lose, then it would go down as a driving without due care and caution, which is a 2-point civil infraction. So it's up to you. If you want to take a couple of minutes to confer with, who's this gentleman again?
I've been with him for 36 years.
Okay, well, if you want to confer with him, talk to him. I saw you looking at him. I don't have a problem. But not from there. If you want to go talk to him, I'll recall the case. Okay, come on back up. You talk to me. What do you want to do?
Just have to take the 1 point and put on my record.
Yeah, it's gonna go on your record. It's gonna be 30 and a 25. You just heard him say that the witness thought you were going in the 40s.
I know you said I can't speak about it because if I do that, I go to trial. I gotta take the 1 point and that's it. They can't be impeding, then it will go on my record.
You damaged a car. Hey, ma'am, please,
Right.
please listen. I'm not trying to trick you here. Your record is not horrible, but it's not the best I've seen. And one of the things I try to do here is if somebody's hurt in the other car or there's something more than minor damage, I don't give impede.
I understand.
Okay? You totaled the car, you put a guy up on the lawn according to the officer. I don't want to quarrel with you about it.
I got it.
You can go to hearing on the whole thing, or you can plead to 30 and a 25, and that would be a 1 pointer. And since there was an accident, I'm going to charge $195.
Okay. That's, yeah, okay.
Is that what you want to do?
Yes.
All right. And you're offering 30 and a 25, correct, officer?
Yes, Your Honor.
To that charge of 30 and a 25, responsible or not responsible?
Me, responsible.
Okay, I'll accept the plea, dismiss the original charge. There is 1 point, and the fines and costs are $195. Okay? You can go down the hall and pay that. You're all set. Please be careful going forward, okay, ma'am? Thank you very much. Thank you, officer. Have a great day. Thank you. The Hamptons versus Tamita Hake and Arif Fuzaman Talakuter, 2504826. Good morning, folks.
Good morning.
Mr. Visconti, your appearance.
Morning, Your Honor. Robert Visconti, P61756 for the plaintiff.
Good morning to you. Okay, folks, can you tell me your name, please?
Yeah, I'm Tahmida Haq.
I'm Arifuzzaman Talukdur.
Okay. Do you guys speak fluent English?
Yes.
Yes.
Okay. So there's a little bit of an accent, so I'm just going to ask you to slow down and keep your voice up when you're talking, okay? I want to make sure we pick you up clearly, all right?
Sure.
Did you guys talk at all, Mr. Visconti?
We did, Your Honor, and we have a resolution of this matter.
Okay, good. Why don't you tell me what it is, sir?
So, Your Honor, we're going to enter into a conditional dismissal in this case, whereby the case would be dismissed, provided that defendants make certain payments that we've agreed upon. The total amount due pursuant to the conditional dismissal will be $1,362.49. And defendants are going to pay that amount in 3 equal installments. Well, actually, there will be 1 installment that'll be a penny less. There will be 2 installments of $454.16 on April 24th and May 24th, and a final installment of $454.15 on June the 24th. If they make all those payments timely, the case will remain dismissed. If they fail to make any payment timely, a judgment will enter in the amount of $2,652.49 less any payments that have been made.
Okay, so there's really a lot of impetus for you guys to pay these. I want to make sure that I cover this with you appropriately. There's going to be a conditional dismissal whereby the case will be dismissed, subject to you paying $1,362.49 as follows. $454.16 on April 24th, $454.16 on May the 24th, and $454.15 on June the 24th. If you pay those, make those payments, the dismissal will remain in effect. The case will remain dismissed. If you do not make any one of those payments timely, this will convert to a judgment, and the judgment amount would be $2,654.49 less any payments that you have made. Do you understand that, Ms. Hake?
Yes, I do.
Do you agree to that?
Yeah, I agree.
Mr. Talukder, do you understand everything I just said?
Yes, I do.
Do you agree to that?
Yes, sir.
Does Mr. Visconti have your permission to sign your name to this conditional dismissal? Ms. Hake?
Yes, he does.
Mr. Talukder?
Yes.
I hope I'm pronouncing that correctly. So
Well,
he's gonna
I go by
sign those.
Arif, that's why my nickname is Arif. I go by Arif if you want to call me Arif.
I'm sorry, say that again?
Arif, I go by Arif, ARIF.
Arif? Okay,
Yes.
okay. Well, do you have, either one of you have any questions for me?
No, actually, he cleared everything very well.
All right, and I reiterated everything correctly, Mr. Visconti?
Yes, Your Honor, you did.
Have a great day, everybody. He's gonna send that in. I will sign it and we'll get you a copy. Have a great day. Thank you very much.
And Ms. Hake, I will send you a copy via email so you can take a look at it as well, okay?
Okay.
All right, thank you,
Good
folks.
luck, folks.
Have a good day.
Thanks. All right, Curtis Brent Hamadi. This is file number 25R513926A. So, you know, we have something about probation violations. Good morning to you, sir. You know, like this, you know, look at some of these stamps that I have, and then I go to probation. And I just put it right here. I look at the date it was issued, so it was issued on March the 4th, 26. And I see this. So, sir, I'm going to go ahead and arraign you on this charge. You have a charge that alleges that you failed to pay your fines and costs as ordered, balance owing $825. Do you understand the charge?
Yes, sir. Yes, sir.
Count 2, that you failed to refrain from violating a law, being convicted of disturbed the peace through this court with the offense date of December 12th of 25. And the conviction having entered on March the 3rd of 26. Do you understand that?
Yes, Your Honor.
Now, that would be deemed a non-technical violation. The violation of law would be. So you could get 90 days on that case. I'm just telling you. Violation of the law of the state. See that? You know how, okay. So you could get 5 days if there is a failure to pay fines and cost conviction, because that's a technical. You've not had any prior violations. You could get 90 days if you plead guilty to the fact that you were convicted of a crime arising out of an incident that occurred on December 12th of 25 while you were on probation. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today?
I did, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing of any kind. Do you understand that?
Understand.
You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like an attorney?
No, Your Honor.
So you're going to waive your right to a lawyer?
Yes, Your Honor.
All right. Can you call in, Beth, please, Sadie? To the charge that you failed to pay your fines and costs of $860 or $825, how do you plead?
I plead guilty, Your Honor.
Did you fail to pay your fines and costs as ordered?
I wasn't paying them, Your Honor, on a timely basis, and then a few months back, I had some emergencies come up.
We'll talk about that, but you didn't pay them as ordered, right?
Yes.
I'm correct?
I was starting to pay, and then I failed to make my payments.
Okay. As the count 2 that you failed to refrain from violating a law, being convicted of disturb the peace on March 3 of 26, how do you plead?
I plead guilty, Your Honor.
Were you convicted of disturbing the peace on March the 3rd of 26?
Yes, I was, Your Honor.
And that arose out of an incident that occurred on December 12th of 25, correct?
Yes, Your Honor.
And you were on probation on December 12th of 25, is that right?
Yes, I was.
Because I placed you on probation back in August?
Yes, sir.
Has anybody forced you to plead guilty?
No.
And you understand, again, by pleading guilty here, that would be deemed a violation of this probation, because you violated the law. And again, your probation could be revoked. And you could get 93 days, actually, not 90. This was an impaired charge. Do you understand that?
Yes, Your Honor.
You still wish to plead guilty?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
I'm going to accept your guilty plea to that charge. Can you please pull up his register from that case? Good morning, Ms. Wiles. Your name?
Elizabeth Foster, Your Honor.
Morning, Madeline. Good morning. This is Judge Johnson. She's the new judge in Taylor. Yes,
Yeah, supervision only.
she's gonna be a superstar. I'll be calling her up and asking her questions in about 2 weeks. Okay, what do we have here? Can I see that sentencing, please? I'm sorry. I want the one disturb the peace one. That's the drunk driving, right?
I'm not sure if Mr. Hamani's been down sentenced by Judge Hessen.
That you're in front of Judge Hessen on that.
Yes, Your Honor, I was gonna go down there after we met here.
Do you have the screening report or anything?
I
Did you order a PSI or a screening on that?
You ordered us a screening assessment on Judge Hessen's.
I want to see the police report on the disturb the peace conviction.
Yep, I have that, but it would be attached to the blue back in her courtroom right now, Judge. I can go grab that.
No,
Here, I have it pulled up. Which part do you wanna see?
I actually, that was an assault and battery that was reduced to disorderly. I think I would like to see that.
I can give you the brief,
Sure.
like circumstances.
Go ahead.
Mr. Hamani, and his girlfriend had visited a gas station. The gas station attendant, insulted his girlfriend. It was Christmas time. She had a shirt on that said ho, ho, ho on it. He alluded to her being, unfortunately, Your Honor, excuse me, being a hoe. And the next day, Mr. Hamani was still a little hot under the collar. And he went in, he ordered coffee at the gas station. He confronted the gas station attendant, and I think when he did get the response he wanted, he threw the hot coffee on the gas station attendant.
Oh,
Mr. Amani's welcome to correct me in any aspect, but that is the gist of it.
What happened, Your Honor, I never threw the coffee on them. I had them in my hands. They were thermoses with the lids on tight. I did react. I kind of, I don't know what happened, Your Honor. I saw red and I shoved my coffees. They hit him and fell on the floor, but he did get splashed with coffee. That's what happened. I lost my cool and.
were you drinking?
No, I was just. He was talking, kind of smack back to me, and I didn't want to put my hands on him, and I don't know what happened. My arms kind of jerked, and I shoved the coffee at him, and they hit him, and they fell on the floor. And I was really unhappy with the way I handled it, and
Why'd you even go back up there the next day?
that gas station, Your Honor, was our morning routine. Literally, I'm friends with the manager there. I bring my dog there. We get our coffee every morning there. It's kind of like our home away from home. I intended to go in there and just confront the guy and say, hey, that wasn't cool. What happened, what you said to my girlfriend. It didn't happen that way.
You weren't there the night before, were you?
No, she went in. I did not. She just told me about it when she came out, and then I handled it the wrong way without.
Let me see the screening report on my case. Yeah, I mean, you shouldn't have gone in and
I
confronted.
should not have. Was no question.
Were there any injuries or anything? Ooh.
No, Your Honor.
You don't have the best record.
Your Honor, I don't know if you remember, I do want to make sure, Mr. Hamani, there is an extra drinking and driving on there. I don't know if you remember, he was here with his attorney. We ended up having to contact Arizona as well as Florida. So that screening assessment was corrected on the record because this was the one that on the police report, it said default and it was not a conviction.
So you had one prior drunk driving in 12, right?
Yes, Your Honor.
And then, but you still had some other cases here. I mean, what do you think?
I will give Mr. Hamani a lot of credit. He called me immediately after the incident occurred to let me know that he most likely would have charges coming. Chief at the time over in Rockwood did communicate with me, sent me over a copy of the police report, and it flowed in the exact same fashion. that Mr. Amati and myself kind of represented as far as what was in the police report. I think Mr. Amati is hot tempered, but I don't think it played a role with any type of, like you had asked about him drinking. There was no indication that this was provoked by any alcohol or drug use.
Where do you work at again, sir?
I actually just got a job. I work for the Metro Parks, contracted to the Metro Parks. So I can definitely catch up on my fines. I can make a payment this Friday.
Do you live in Rockwood still?
I do, Your Honor. I just sold my house. I'm set to close on my house the first week of April.
And then where?
Everything's been.
And then where? Then where are you gonna go?
I'm actually gonna buy a trailer and
Where?
Here. Somewhere. I don't exactly know yet.
Anything else, Ms. Wiles?
I will say he is compliant with all the other aspects, Judge. He has all his programs completed with the exception of treatment, which he is continuing in. I've updated report from March. He's testing under orange monthly at DNA. It is negative. He was out of town and approved for a little while. His daughter was very ill. So he did have a small hiatus, but he kept in great communication, Your Honor. He is very compliant with other aspects.
He's scheduled to come off probation. It would be in February the 7th of 27, right?
That is what I have, Judge.
Anything else?
No, Your Honor. Just that, I'm sorry that this happened and I definitely feel like needed.
Well, at least you're respectful. I'm not impressed with your record. Some of it dates back a long time. And at least you're acknowledging you did something wrong. That means a lot to me. You're gonna pay costs of $50. I'm gonna order 2 days on the court work program, and you're gonna pay $35 a day for that, for a total of 70, for a total of 120. I'm gonna let you pay your fines and costs at the rate of 50 per week beginning April 10th. I want you to remember what I said to you. If you don't have the money, it's not the end of the world, but you got to communicate with us, okay?
Yes,
You got to come and talk to me, or you can call in, go on Zoom. I'll be glad to give you an extension. I don't care how many times we have to do that, all right?
Yes, sir.
Okay, so she'll set you up. I wish you well. Hey, listen, no more contact with courts, okay?
Yes, sir.
All right, good luck.
Thank you, Your Honor.
All right, thank you.
Yes.
Do I have anything else down there, guys?
No, we just wait on my theories.
What about the one with the sentencing? What time is that scheduled?
Well,
1 o'clock.
Okay,
This would be really.
all right. What is your name, sir?
It's Mr. Man, he's 9:30.
Is that a civil?
Yeah.
Who's
It's
the plaintiff?
small claims.
He's the plaintiff, small claims.
Oh, okay, so we don't have the,
Do you have Thompson's appliance out there, Jim?
No, they're not on Zoom.
Okay.
Nor the small claims are told to come in person.
Oh, okay.
all right, so I'm gonna
You got a few-
get off, sir. If they're not here in 15 minutes, I'm gonna come out and enter a default. If they are here earlier, I will come out. If they're not here, you're gonna win. Still the prince
Correct.
in a while. All right, advantage one versus Deontay Coleman.
Where's that one?
How are you? I haven't seen you in a while. 2504868. Your name?
Me with the data for credit union.
All right. I'm going to ask you to. Deontay Coleman is not here, right, Jennifer?
Correct, Your Honor. He's not on Zoom, and I believe he's not in the courtroom either.
All right, I'm gonna ask you to raise your right hand. You solemnly swear to affirm under penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you got.
Yes, sir.
Okay, so you have here a claim that indicates that the defendant owes 1167.17, correct?
Yes,
Is that still the principal sum before we get to everything else?
yes.
And you have what kind of costs here?
The costing was $50 for the filing fee,
Okay,
and then 51 for the original service. And then we did have to file for an alternate service, so there's $55 total for that.
so you've got, correct me if I'm wrong, 50 plus 51 plus 55, right?
Yes,
So that's 156. And you're gonna add that to the, so it should be, correct me if I'm wrong, $1,323.17.
yes, sir.
All right. Judgment for plaintiff. I gave defendant time to appear. This was scheduled this morning for 9:30. Defendant was given 15 minutes. It is now 9:50. I'm signing the judgment. We will send this one down and you are all set. Do you have any others in front of me?
I'm sorry, what was
You
that?
don't have anything else in front of me, right?
No, not today. I'll be back Monday though.
Well, good to see you. I haven't seen you. You've been sending in all the, is it you sending in all the consents all the time?
Yeah, probably. On one of the last ones I had, it was probably at least 10 cases, and I think I only had to come in for 2 of them.
Okay.
I consent, so it was really good.
Well, that's good. Thank you.
I did have, already filled out a pre-judge, like a judge that already filled out.
See, you're too good, but I filled one out anyway.
I see you already.
You're all set. Thank you. Bye now. Edward Mann versus Thompson's Appliance, 2600096. Gosh, I hate these. Your name?
Edward Mann.
You paid him and they didn't show up.
I gave him a $200 deposit and he never returned the report.
Look, I wish I could give you, I see you're asking for, to be paid, for the amount of time that you waited at your wage rate of what, $47.25. I just can't do that. I wish I could, but I can't. So I'm gonna enter I just don't understand some of these people. I mean, how corrupt is that to take money and not show up? I'm going to give you your judgment. I want to make sure I include everything that is out of pocket. You had a $42 filing fee, right?
Yes.
What about a service fee?
Your Honor, he had a $42 filing fee, a $20 motion fee because he had to do alternate service.
Right.
And then $69.25. So in service fee, so $131.25 is what I'm showing.
And then there was another $20 for a second mailing that I paid last time I was in the court.
How much are you coming up with?
I've got $331.25, not including any of the hours of my time in that kind of thing.
Yeah. Yeah, I just can't do that. I'm sorry. I'll give you your judgment. It'll be for $331.25 for the record. Case was scheduled for 9:30. I gave the defendant 15 minutes. It's now 9:53. So if you go down the hall, he'll bring the file down. They'll give you a copy of the judgment before you leave. Okay?
All right, thank you.
Have a great day.
Thank you.
Good luck on collecting that.
Well, I was gonna ask.
Well, you send that to them, and if they don't pay you within 21 days, I would set up a creditor's exam. And that's a subpoena where you can tell them they have to bring all their bank records. There's forms you can go online and look at. Like, just think if you were trying to collect from me, right? You'd ask me to bring my W-2s, my tax returns, my bank account statements, my stocks, my bonds, whatever it is that I have, and then you can examine, then you can start garnishing.
Okay.
Okay?
Yes, am I able to just some report on that? If
We can't give legal advice, but they
just would go to
Yeah, we can give you the subpoena for a creditor's exam.
Okay.
And you can actually take one of those forms now and look at it. And hope that he pays within 21 days. If he doesn't, then you can go after him. And that, that's where I would start anyway.
All right.
Okay?
Thank you.
Best of luck, Mr. Mann.
Thank you.
Cavalry SPV 1 versus as assignee of Citibank versus Sabrina and Paul, 2600394. Good morning.
Good morning, Your Honor. Angelina Abu-Farha, P number 88197 on behalf of plaintiff.
Good morning, Miss Paul, your name?
Sabrina Paul.
Did you two talk and try to work something out here, counsel?
Yes, we did, and defendant did offer a settlement. I do believe my client will accept. I do have to go through the procedure of submitting it to my client, but I have high hopes that they'll accept and this will
You
be
need to
settled.
do that.
I'm sorry, Your Honor.
I'm going to give you an adjournment. I'm just asking how long it will take for you to get a hold of your client.
Not that long. They respond fairly fast, so if you want to adjourn for 30 days, that'd be good.
All right, give me a date 4 weeks from today, that week that I'm here, if you
April
would, please.
27th.
April 27th, we can make it at 8:30, Jen?
Yes, Judge.
April 27th at 8:30. And we'll go from there, okay, Ms. Paul? You don't have any objection to that, right?
No, that's fine.
So I'll adjourn that pretrial again to April the 27th. And that will be at 8:30 in the morning, and hopefully you guys will resolve it. If you have the dismissal order in hand before that, because it's been resolved, then you don't have to show up on the 27th. But if you don't have a dismissal order, I would still appear by Zoom on that date and at that time. Okay, ma'am?
Okay.
All right. Anything else, Ms. Abafar?
No, Your Honor. Thank you.
Have a great day. Thank you.
You as well. Thank you.
Thanks. All right.
We have an in custody in downtown. I called him, just waiting for him Zoom.
Okay. Is Mr.
Shut.
Okay.
What's your name?
Tom Pascage.
Is that a phony or?
Yep. It's that beat on record Morrison did the other day. CSC.
Oh,
I called him one time.
see. So, you guys see who she is?
Yes.
Infinity food. Everybody is.
He said 30
And I sat there, but I couldn't figure out.
Oh, like their organization.
Yeah.
where Stuff goes.
Yeah.
And I'm very particular about stuff like that, so it's something I'll definitely have done.
Right.
Thank you.
Did you hear from them yet?
He said 30 seconds. 30 seconds.
All right. Why don't you call in Mr. Shemke?
You have the sentence actually.
Do I have
Here you go.
Christopher Scott Cowgar, 26B704030. Would you text Mr. Shannon?
Yeah.
One second, sir. We're waiting for your lawyer to walk in. All right, again, Christopher Scott Cowgar, 26B704030. Your name, Mr. Shemke?
Maybe have my client's time to send to managing her via Zoom as the arraignment to a formal reading by client's name.
Sir, your name?
Christopher Cowger.
Detective, your name?
Detective Sergeant Morrison, Brownstown Township Police Department.
All right, so we have here, sir, give me 1 second, please. Yeah, I signed the complaint in the back. Goes in the front. But at any rate, you have 4 counts of CFC 2. You have 1 count of CSC 4. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, Your Honor.
You have the right to be represented by your lawyer not only today, but at all subsequent court proceedings. If you ever choose to submit the questioning with law enforcement officials, you have the right to be represented by a lawyer at that questioning as well. Do you understand that?
Yes, Your Honor.
You have the right to a probable cause conference within 14 days. You're going to be in front of Judge Hessen on that. The probable cause conference will take place on April the 7th, and that will be at 9:15 in the morning. You're going to be in front of Judge Hessen on that. At that time, your lawyer will discuss this case with the prosecutor. At the preliminary exam, that will take place on April the 14th, and that will be at 11:15. At the preliminary examination, as to each one of these counts, sir, they have to prove that the crimes were committed and that you were the one who probably committed the crimes. If they prove that, you will be bound over for further proceedings to the Wayne County Circuit Court as to any count that they prove that as to. If they fail to prove probable cause as to all counts, then they'll all be dismissed and you will be discharged. Do you understand that?
Yes, Your Honor.
So again, I'm going to repeat, probable cause conference will be on April the 7th at 9:15. Preliminary exam will be April the 14th at 11:15. Do you intend to hire? Talk to me, Mr. Cowgar. Are you?
I was asking the sergeant if he could write down those dates and times for me.
We'll get them to you. And also, I want to make sure that you understand that you have the right to fill out a petition for a court-appointed lawyer. Do you intend to hire your own lawyer, or are you going to file a petition for a court-appointed?
At this time, I'll do a court-appointed.
Okay, so he'll make sure that you fill out a petition before you leave. All right, let's address bond. What would you like to say?
You know, my client's 47 years old, currently lives in Brownstown with his wife and kids. He does work at Princeton. He's a structural builder. I know that he recently he purchased some properties. So financially, he'll have a difficult amount with a high monetary. I'd ask for consideration for reduction of bond, at least a 10% or cash surety provision. Thank you, Judge.
How long have you lived at 18411 Pine West?
7 years, Your Honor.
I'm sorry, how many years?
6 or 7 years, Your Honor.
All right. Detective, what would you like to say on this?
Your Honor, I would ask the court to consider a cash bond. Also, no ability to leave the state unless first seeking permission from the court, and also no contact with any minors under the age of 18.
All right, sir, I'm going to tell you your bond conditions first. You cannot leave the state without the consent of the court.
Officer Nelson for probation. We're here today for a hearing on the motion for intervention in lieu of conviction. I'm going to deny the motion for intervention in lieu of conviction because, Mr. Truong, you're not eligible because one of the victims is elderly. At least one of the victims is elderly. And it's my understanding we're going to enter a plea of guilty to, we got 6 counts of theft of mail, and we're going to go forward with sentence today. Is that accurately stated?
Yes. Yes, Your Honor.
Mr. Truong, how old are you?
I just turned 20.
How far did you go in school?
GED,
Are you-
12th grade.
Are you able to read and write English?
Yes, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Are you taking any medications?
Just insulin.
Anything that would interfere with your ability to understand what we're doing here today?
No, Your Honor.
Are you a United States citizen?
Yes, Your Honor.
If you enter a plea of guilty to this charge, we're going to go forward with sentence today. I'm going to release you from the jail, place you on electronically monitored supervision with a curfew for a period of 60 days and give you some stuff that you have to do. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will? I have a document entitled Change of Plea and Entry. It's like on the second page is a signature above the line defendant. Is that your signature?
Yes, Your Honor.
Did you review this with Mr. Gibbs before you signed it?
Yes, Your Honor.
Are you satisfied with the representation that you received in the case?
Yes, Your Honor.
You're going to enter a plea of guilty to 6 counts of theft of mail. They're each 5th-degree felonies punishable by up to 12 months in prison and a $2,500 fine. If you violate the terms of your community control and I have to send you to prison, it also carries with it an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished, and you either plead guilty or the state of Ohio proves that you're guilty. If they can, you have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, Your Honor.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on November the 19th of 2025 in Deerfield Township, Warren County, state of Ohio, that the defendant did with purpose to deprive another, exert control over the mail of 6 separate individuals without their consent or authorization.
Anything on those facts, Mr. Gibbs?
Nothing further, Your Honor.
Mr. Truong, did you hear those facts?
Yes, Your Honor.
Do you admit they are true?
Yes, Your Honor.
Do you understand the rights you're giving up by entering a plea?
Yes, Your Honor.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to treat the ILC report as a PSI and go forward with sentence today?
No, Your Honor.
Mr. View, we have 9 days of jail time credit, no restitutions. That sound right?
That's correct, Your Honor. We have been in contact with a number of the victims in regards to the case, and I believe their primary concern was objection to intervention in lieu of conviction based upon their understanding of the defendant's prior juvenile and adult criminal history. Beyond that, we have no other recommendations beyond what we discussed in chambers for thinking for a change in IOP.
Mr. Nelson, anything from probation?
Nothing further, Your Honor.
Mr. Gibbs?
Your Honor, I would just mention in discussions with my client, he does show sincere remorse for this situation. He has wanting to get back to being able to work, being able to be a productive member of society, and he recognizes that this is not a path that is going to lead to anything good if he continues on it. He has an involved family, adoptive family, that have been in regular communication and seem to show a very high level of involvement and care in the outcome of the situation for him. And we thank this court for the opportunity to move forward.
Mr. Truong, anything you want to tell me?
No.
It's going to place you into my community control program. I'm going to do that for a period of 3 years. I'm going to impose upon you the standard rules of community control, delegate to your officer the ability to make special or additional conditions as they see fit. At this point, it's going to be a special term of your probation that you enter into and successfully complete drug and alcohol treatment. The court's thinking for a change program. I'm going to place you on electronically monitored supervision with a curfew for a period of 60 days and give you credit for the 9 days of jail that you have already done. You just need to make sure that you have a stable address, and then we'll get you out of jail. If you don't have a stable address to go to, then the community corrections people will help you find some place to go.
Okay.
If you violate the terms of your supervision or you leave the state without permission, I can sentence you up to the maximum penalty in this case, which is 12 months in prison, plus the period of post-release control that I told you about a couple of minutes ago. I'm not going to impose a fine. I am going to impose the costs. You do have the right to appeal this to the 12th District Court of Appeals in Middleton. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you without charge. Good luck to you, Mr. Jerome. Nobody can get that one right. Hold on just one second.
What the possible consequences are if you go to trial and what the offers are. And I see that you've signed new plea bargain rejections with your attorney, Mr. Eckhart. And did y'all go over everything, all of the discovery, what your possible consequences again, and all of that before you signed these today? And obviously the evading arrest or detention would end up being the most serious offense because it's a third-degree felony, and with your criminal history, if those convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to life in prison. You understand? And all of these plea bargain agreements or rejections are the same as before. It looks like 7-year offers, all of the cases to go on either count one, whatever adds up to 7 years, waiving those habitual enhancements. Again, you've got every right to reject these. I do want to make sure you understand that once your case goes on the trial docket, I will not accept these plea agreements after today. Your case will be expected to go to trial, or there would be some different agreement. The only way it would be this or something lower is if some new information came out that your attorney or the state's attorney doesn't know at this time. Do you understand?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set on the trial docket, and Mr. Eckhart will begin preparation for trial. You can go back with the bailiff.
Thanks, Judge.
Sarah Jordan on page. We are resetting Sarah Jordan. She's on page 8.
Yes, ma'am.
Well, he's not here again today. Yeah, it still has to be here. Okay, I'll do it in a second. Mr. Eckhart, you have Michael Victoria.
You, Judge. Michael Victoria.
And now Mr. Smith.
Good one.
Since she doesn't have that ready.
Philip's been working on getting an offer. We have that. I've got the discovery.
Let's get him out and then I'll let you. Good morning, sir. You're Michael Victoria.
Yes, ma'am.
And Mr. Victoria, in cause number 21-36410 and 21-36411 is charged with murder in each of those cases. And what is the announcement?
Judge, over the past few weeks, Mr. Smith has been working on getting us an offer. He did so last week. We've already kind of done some preliminary discussions about it. We're not prepared at this point to say yes or no. We still need a little bit more time to go through all the discovery, and we're asking for 60 days to do so.
Discovery is being in the sentence.
I'm sorry.
Discovery is going in the sentence.
So what I'm willing to do based on, and I know these are old and there's a lot of discovery. We talked about that before. I will do one last reset. I'll do a 60-day reset. That should give you plenty of time to get through everything yourself and then get through it with Mr. Victoria. And then when we come back, is there anything that we're waiting on that you know of? Okay. So now that you've got everything, we'll get an announcement one way or other at the next 4 days.
In 60 days, we will be able to.
Perfect. Thank you, Mr. Carter. You can go back with the bailiff.
All right.
You run with I have to put you reflection. You need to see running up the flag.
And then like the, what restaurant was that? Where you, yeah.
He's running flag on here.
Mr. Rojas, are you ready on, Bradley Hudson?
Yes, ma'am. Bradley Hudson.
We just don't, is there one or is there another coming?
I just need the second one. What? Second.
We're just going on one.
Yes, ma'am. One's gonna be dismissed.
Good morning, sir. Are you Bradley Aaron Hudson? And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
And are we going to count one only?
Yes, ma'am.
Second to get that quickly. It alleges you committed the second-degree felony offense of aggravated assault with a deadly weapon from January 9th of 2026. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hudson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, follow your agreement, find you guilty of aggravated assault with a deadly weapon, sentence you in accordance with that agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will also sign a dismissal as part of this plea agreement and clause number 26 DCCR 0153. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
They're gonna be reset, Judge.
All right, let me write this on this. I forget now. Kelvin Johnson.
That's gonna be a, plea.
Okay, Kelvin Johnson.
Kelvin Johnson. Yeah.
Good morning, sir. Are you Kelvin Johnson?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will.
Judge, with the court's permission, we need to go on second degree count, so whichever the court prefers.
Somebody didn't sign.
The defendant, I signed in the wrong spot. Sorry.
Oh, I didn't get him.
That's okay. Mr. Johnson, in cause number 25, DCCR 1781, you're charged with the state jail felony offense of theft of property with previous convictions from October 9th of 2025. The indictment alleges you were previously convicted of theft August 18th of 2022 and January 5th of 2023, and then April 15th of 2024. The indictment further alleges that you were convicted of delivery of a controlled substance, a state jail felony, February 9th of 2004, 2 cases on that same date of delivery of a controlled substance. And how do you plead to that charge? And are those prior convictions all true?
Yes, ma'am.
Did you enter your plea of guilty and true, freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison, which means you're leaving your punishment up to me. And as long as I follow the agreement, I cannot give you more than 5 years. Give you 5 years, I can give you less, I can consider probation. All of that will be determined when we come back for sentencing and I get more information and a pre-sentence report and things like that. You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, then you're waiving that. And is that what you want to do? Right. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. I find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do that report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come.
Yes, ma'am.
All right, we'll see you back at sentencing. You go back with the bailiff. Then you've got Willie Pugh.
It's gonna be a rejection.
Good morning. Are you Willie Edward Pugh Jr.? Give me just a second, Mr. Pugh, to get this pulled out. Mr. Pugh, in clause number 25, DCCR 1835, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from October 23rd of 2025. The indictment alleges that you were previously convicted of the third-degree felony offense of unauthorized use of a motor vehicle, May 13th of 1996. 2 cases of that same offense on that same date. After those were final, you were convicted of the felony of unlawful possession of a firearm by a felon, February 20th of 2007. You were also convicted on that same date of possession of a controlled substance, a third-degree felony. After those were final, the indictment shows that you were convicted of evading arrest or detention with the use of a vehicle, April 15th of 2019. And on that same date, also possession of a controlled substance, a second-degree felony, and unlawful possession of a firearm by a felon, also on that same date. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to go forward probably on, it looks like counts 1 and 2. That would make this a second-degree felony for a 14-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
Okay, I'll get that done. Ms. Malfino, is there any reason to believe that that offer would change? Any information you think you don't have at this point?
Judge, just to be candid with the court and not to give the defendant any false hope, I'd like to speak with the officer actually in person rather than the review of his report. There might be some question as to the validity of that search. I'll certainly bring that to the court's attention well prior to the trial docket. That would be the only reason after speaking with him that I would consider altering the offer with the court's permission. He's been before you, Judge, multiple times with 10 and 12-year sentences reason for the
And
I
Judge,
could do that very quickly.
if you'd rather just reset a week or 2.
I would I would rather if you can get that done in 2 or 3 weeks, just to do a regular reset. That way we can all say with at least some certainty that the offer is what it is based on the evidence and based on your discussions, or if something changes, then we'll take care of it one way or the other. So let's do this. I'm going to delete that plea bargain rejection for now. I'll reset it for about 3 weeks. That'll give Ms. Malfino time to speak in person with that officer, get with Mr. Rojas. He'll get with you, let you know what the final discussions come out to, and then we will see where we get at that next court date. Okay, you can go back with the bailiff.
This might just read different on the problem because the
Okay.
conversation.
Sure, yeah, that's good. Brian Trejo.
I'm going to ask for a reset on that, Judge. I'm still trying to run down witnesses that were.
Okay, it's pretty new. Mr. Nichols, and we'll set Brian Trejo. I think that's all you have.
Sarah Jordan's going to be reset along with the co-defendant.
I think I already got that one. Yeah.
That's it. Thank you.
Thank you.
Good job.
Mr. Parker,
Yes, ma'am.
you've got Christopher Holman. Okay.
Yeah, text with the guys. We go out on Wednesday. Ruben from office, send me a picture. Marcus crawling.
Mr. Coleman.
Morning, Judge.
We need them to get a fingerprint real quick first, please.
I got everything resolved with you. It's only Ashley that I'm.
I wasn't trying to call out anybody.
Pretty bad.
Just pointing. We did. Thank you. I will make it this week.
Good morning, sir. Are you Christopher Holman? Speak up, please.
This one.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Holman, in clause number 24, DCCR 0814, you're charged with the state jail felony offense of theft of property with previous convictions from February 7th of 2024. The indictment alleges you were previously convicted of theft August 4th of 2020, and then after that was final August 10th of 2021. And how do you plead to that charge?
Guilty.
And are those prior convictions of theft true? Speak up, please.
Yes, ma'am.
And did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Holman is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. And at this time, in accordance with your agreement, find you guilty of theft of property, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Okay, Enrique Garcia. Did you do this?
I gave it to her. Oh, I'm sorry.
Oh, we did the wrong one.
Oh, I had it in the wrong file, I guess.
You know, there's, you need certain defendants up there to make sure you do that right.
Oh, very French. Oh, she goes.
Your Honor, the state's electing to proceed on defendant 1244. We're asking the court punishes defendants as a misdemeanor.
With a state jail felony conviction.
Yes, Judge.
Good morning, sir. Are you Enrique Garcia III? And Mr. Tucker, will your client waive the formal reading of the indictment?
You would, Judge.
Mr. Garcia, in cause number 25, DCCR 1057, you're charged with the state jail felony offense of unauthorized use of a vehicle, and that's from June 11th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving him any right to appeal? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent?
No, Your Honor.
All right, Mr. Garcia, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle, sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code, You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification. This shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. You can go back with the bailiff.
Judge.
See, Donald Cogdill.
He's gonna be a little bit difficult. He's not combative. He's just.
Last time you said.
No, I'm telling you,
Okay.
make sure you, he's like questioning the, that was my thing 100 times and.
All right.
I thought they would just come back with another offer. I mean, this is the best offer. You know, try to go through it with it. He starts questioning me. I'm the judge. This is the judge. Well, I understand.
Good morning, sir. Are you Donald Cogdill? Are you Donald Cogdill?
Yes, ma'am.
And Mr. Cogdill, can you hear me okay?
Barely.
In cause number 26 DCCR, excuse me, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions. And that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true, that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Do you understand that?
The way he's talking is, it's gonna be a lot better, worse. I mean, I don't understand.
What do you not understand?
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker. That shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
Well, I better take the,
Listen, just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay? I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Do you understand?
Yes.
So go ahead.
I'm sorry, Judge, if I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading, so we were actually even going to come to the court with seeking your permission for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute. Thank you.
Page 4, I'm so sorry for that I wasn't screwing in.
Apparently he had like 15 cases, remember there's one not finished. And they don't do those.
Brandon Benton.
Yes, ma'am.
Okay.
Put it with the.
Oh, gotcha. We are resetting Brandon Bonte.
Oh, yes, no.
Bring that. That's gonna be-
Mr. Lewis, you have Ephraim Dinkin.
Yes, ma'am.
Morning. Good morning. Are you Ephraim Dinkin?
Yes.
And Mr. Lewis, will your client waive the formal reading of the motion?
He would.
Mr. Dinkin, and cause number 19-32080. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 12th of 2019 for aggravated assault, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation office for the months of September and October of 2023. And is that true or not true?
Yes.
True or not true? Thank you. Count 2 alleges that you failed to never become intoxicated or under the influence of any intoxicating substance, and that you tested positive for alcohol June 19th, July 12th, and August 28th of 2023. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of entering and successfully completing the anger management program as ordered. Is that true or not true? Count 4 alleges that you were behind in your court assessed fees. Is that true or not true? And then count 5 alleges that you failed to complete the drug rehabilitation orientation program, or the DROP program. Is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Did you plead true, but did anybody force you to plead true to those counts? Okay. Did you plead true because
True.
they're actually true?
True.
Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 10 years in prison. And so as long as I give you 10 years or less, you understand that you're waiving any right to appeal, correct? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Dinkin is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. get the probation department to do an updated report. And then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis and he'll present it to me on your behalf when we come back. All right. See you back at sentencing. You can go back with the bailiff. See, Mr. Lewis, you've got April Smith.
April Smith. Sending the paperwork on that.
What, I have a notation that there's new cases coming. Are those?
Update.
Okay.
Yes, ma'am.
April Smith.
She's running the CDC.
Okay, that's fine, because I think she'll probably need to get her over here first for fingerprints. Yeah. Arthur, Mr. Bynum.
Thought about y'all last night. Did y'all feel the boom? Never felt it.
I was,
Gym.
I never felt it. Okay, let's see. This is. I don't. You've got April Smith coming. Oh, there it is. Just popped up. As soon as I said it, of course. Good morning. Are you April Smith? And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Judge.
So it's just open.
It is, Judge, and just to update the court, it's my understanding that Ms. Smith is going to plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times to the detectives to ask them to bring those new cases. I believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just going to go open to the court on the full range of punishment with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am, or Mr. Lewis, will she waive the formal reading of the motion?
She does, Judge.
Ms. Smith, in clause number 19, 33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions, May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm going to make that change because.
The only reason I did that is because we had the agreement.
Oh,
the new
No,
case.
it's just fine.
Okay, so there
Not
is an
proper.
agreement,
Right,
actually.
It was actually.
Thank you, Mr. Lewis.
And Judge, I'm sorry, I misspoke earlier. The offense dates are in May. We checked after our last setting in January.
Right.
And asked them to file them and they still.
Okay.
Yesterday.
Okay, thank you. So the agreement is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them. And that's part of that plea agreement, which means no matter what I do within the range of punishment, which is up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Ms. Smith is not competent?
No.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? See you back at sentencing.
Thanks.
Crystal Julian, sentencing, Mr. Lewis.
Assistant Public Defender Ben Dunlap for Mr. Morgan, who is joining me at the podium. Mr. Morgan, would you state your name for the record?
In each of his cases, I had before me a plea form that indicates that he's going to plead no contest to, in the case ending in 5820 or 5320. He added count 4, counts 1 and 3 would be dismissed. And in the other matter, he would be pleading to an added count 2. Both counts are aggravated assault. There is further a sentence agreement and no upfront jail. That's the court's full understanding of the agreements.
The defense agrees. Thank you.
Yeah, I haven't lost.
You solemnly swear to affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Shane Morgan. Mr. Morgan, if this court's understand. Back, solved. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that, sir? Yes, sir. Do you understand what a no contest plea is? Yes, sir. Two things about a no contest plea I have to make sure that you understand. First is it means that you're not further desirous or wanting to contest these charges. You understand that? Yes, sir. Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that, sir? Yes, sir. You understand, sir, that although I'm taking your plea, I would not be your sentencing judge. And in the case ending in 5820, you would be sentenced by Judge Garwood. And in the other matter, you would be sentenced before Judge Perry. Yes, sir. You understand that, sir? Yes, sir. Basis for the no contest, please.
Lack of memory.
Sir, to the charge of aggravated assault as contained in the case 5820, how do you plead? No contest. To that same charge as contained in the other matter, so it's at 55, can't read their writing. 5535. How do you plead? Guilty. Or no contest, no contest. You understand that by pleading no contest, you will not have a trial of any kind? Yes, sir. You signed an advice of rights form in each of these cases? Yes, sir. Any questions regarding any of those rights? No, sir. Let's get a look at paragraph 5. There's a copy on the podium.
This is the same for me.
Those are your rights, which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form. Yes, sir. You understand you're giving up your right to appeal of right. Yes, sir. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today to get you to plead? No, sir. Anybody threaten you or coerce you? No, sir. You're doing this voluntarily and of your own free will? Yes, sir. Court has been provided and has reviewed Ann Arbor Police Department report for their case number. Get to it. So, no. Close it out. Actually, University of Michigan Department of Public Safety for their case number 2590304546. And in the other matter, University of Michigan Department of Police report for their case number 267326. Any objection to the court having reviewed those reports?
None from the people. Thank you. None from defense.
Based upon a review of those reports, court does find that there's a sufficient factual basis in which court could find a defendant guilty of these offenses. Sir, I do have to advise you upon me taking your plea that if you commit misconduct between the time I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Yes, sir. Is counsel aware of any other promises, threats, or other inducements which have led to these pleas?
No, Your Honor. Thank you. No, Your Honor.
And have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea to count 4 in the case ending in 5820. Counts 1 and 3 are dismissed. And in the other matter, we'll accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14th or 15th District Court probation. Sentencing in this matter will be set for
5820. It's going to be April 28th at 9 a.m.
April 28th, 2026, 9 a.m. That's the sentencing before Judge Garwood. And in the other matter,
April 24th at 8:30 a.m.
April 24th, 2026, 8:30 before Judge Perry. Bond will continue.
Did the court dismiss counts 1, 2, and 3 on that case, or was it 1 and 3?
Just everything that needed.
Thank you, Your Honor. Appreciate it.
Thank you, Your Honor.
Court does call the case of People versus Giovanni Moot. Cases.
Good morning, Your Honor. James Fifelski appearing on behalf of Mr. Moot on the case ending in 1665.
Morning, Judge. Brian Bowling, Assistant Public Defender on behalf of Mr. Moot in cases ending in 5712 and 5718.
Okay. And are these all waivers or?
In case number 5718,
Yes.
the necessary witness is did not appear in the claim with the examination.
I would move, my understanding is that both charges would be dismissed here, Your Honor, so I'm moving to dismiss both charges based on.
People being unable to proceed, cases dismissed. That's on defendant's motion. All right, and the other matters, sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Correct.
People also waive their right?
Do judge, and for the record, we did make a plea agreement prior to the waiver where Mr. Luke has been waived, respect to waive, and plead to the charge in 5712, that being possession of a narcotic thing. And then in 25F2165, we will offer a plea to largely $201,000 in circuit court as a global resolution.
That is my understanding of the people's offer as far as my case is concerned, and also awareness of the other case, and have discussed that with Mr. Moot, and he does wish to waive based on that offer.
That's my understanding of the agreement, Your Honor.
All right. Defendant having waived preliminary examination, he's bound over to circuit court in the case ending in 5712 on count 1, and in the other matter counts 1 through 3. As to the arraignment, gentlemen.
Oh, yeah, waive formal reading of the charges in my case ending in 5712. Your understanding is as for a pretrial thing.
Defendant having waived, oh, go ahead, Mr. Fred.
Acknowledge receipt of the information, waive formal reading, and stand mute as well, Your Honor.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea to the 4 counts. Pretrial in these cases will be set for
May 19th at 1:30 with Judge Conkey.
May 19th, 2026, 1:30 before Judge Conkey. Bond will continue. Thank you.
Thank you very much, Your Honor.
One moment.
You want I'll do the real what that.
Think they're both in. Court calls the case People versus Bobby Tennyson.
Morning, Your Honor. Raymond Cook for the people. David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Bobby Tennyson.
It's waiving.
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right?
Yes, Your Honor. And I mean, put that on the record.
Go ahead, yes.
Full offer to agree not to add a legal offender notice in each.
That's correct. That is correct, Your Honor.
Looking for why. I don't know. Why do I not have information in here?
Thank you.
Well, Your Honor, I don't intend this as an insult, but I have a copy of the information.
No, I've got it now. Well, I've got a copy of the complaint, or at least the front one. All right.
Your Honor, my client waives.
Examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, and 4.
There's 6. I think there's 6 counts total, Your Honor.
Well, I have.
There's the drug counts, and then there's 2 counts of firearm.
Yes, I see 6. All right. So it's actually counts 1, 2, 3, 4, 5, and 6. You're right. Got it. It's on the other page.
There's only 6.
Your Honor, I believe there may be, the information I'm seeing on file has 8 counts.
Except the one that I have has two of those counts by the magistrate count what would have been the original complaint, counts 3 and 4, that there was a finding of no probable cause.
Understood. Thank you.
Yeah, the copy I got when I got my discovery, Your Honor, has 3. I have 6 counts total.
I'll update our file then. I apologize.
He's bound over on all 6 counts, Mr. Golson.
Your Honor, we acknowledge receipt of the information, copy of the information. My client waives its reading, stands viewed as a not guilty plea be entered.
Defendant every way for reading, standing mute, court will enter not guilty plea. Pretrial will be set for
May 19th, 1:30 with Judge Punky.
May 19, 2026, 1:30, Judge Coffey. Bond continued.
Your Honor, there is a co-defendant who was bound over to Judge Hamoud. I suspect I should just deal with the circuit court on that. I believe it was Judge Hamoud. Right?
Yeah. Mario Taylor was bound over to.
I have judged this case in 2 places. This Judge Conkey.
I'll deal with circuit court, Your Honor.
Bond will continue.
Thank you.
Court calls the case, People versus Kenya T.
Rock out as this prosecuting people.
Your Honor, Michael Vincent on behalf of Mr. Kennedy.
Sir, your name again? All right, now go ahead.
Not going to proceed. We're unable to proceed at counts 1 and 2. I've added counts 7 and 8, which is child abuse 4. Here's me. Should be in bed tomorrow.
Make an appointment, come and see me. So is it going down on 3, 4?
Yes.
5, 6, 7, and 8?
Yes.
As to count 7 and 8, you waive formal reading on those, Mr.
Yes, Your Honor.
And submit to the charge.
And we have a copy of the new documents.
So I'll dismiss counts 1 and 2. Continue as not guilty plea as to counts 3, 4, 5, 6, 7, and 8. That a pretrial in the factor April 15, 2026, 8:30 before Judge Barr.
Your Honor, if I may, I want to say this for this man who I highly respect.
What?
If I may, regarding this man who I highly respect, the child abuse is
respect you.
Yes, sir.
Really?
Yes, sir.
Wow.
We go back, Patty. So for either one of us hitting grave beer.
Oh,
Okay.
we're gonna.
But the child abuse was a seatbelt. I want this court to know that this man doesn't do what he's accused of.
All right. All right. Thank you, sir. Bond will continue. I don't. I used to have since then. Court calls the case People versus Stephen Winchester.
Your Honor, Raymond Cook with People.
Morning again, Your Honor. Dan Garrett on behalf of Stephen Winchester.
You just been hanging around all day?
Good morning, Your Honor. My name is Stephen Winchester.
Separate preliminary exam, people are unable to proceed if there's a necessary witness. We're unable to get a hold of. I spoke with Mr. Aaron. There's going to be some additional investigation. We're going to try and get that witness. We're likely to reauthorize once that becomes available. But at this point, I'm unable to proceed.
The client understands that. Your Honor would move to dismiss without prejudice.
Being unable to proceed, this case is dismissed. That's with on defendant's motion without prejudice. All right.
Thank you very much, Your Honor.
Thank you, Your Honor.
Down to 3. Onto the jelly. Oh, and with them. In my
That one, hers is over.
May I approach the bench?
Oh, boy. Yes, you may. Come on, it's gonna take a while.
Cogdill. All right, sir. Again, you're Donald Cogdill.
Yes, ma'am.
Can you hear me okay like this?
Yes.
And will your client waive the formal reading of the indictment?
He will.
Mr. Cogdill, I have to go through that indictment again, even though I already did. In cause number 26, DCCR 0005, you are charged with the state jail felony offense of evading arrest or detention with previous convictions from June 25th of 2025. The indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. It further alleges that you were convicted of burglary of a habitation, first-degree felony, December 22nd of 1993. After that was final, you were convicted of burglary of a habitation, a first-degree felony, November 7th of 1994. That's enough for a second, if that's okay.
Yes.
How do you plead to that charge?
How you plead? Guilty?
Guilty.
And are those prior convictions true?
Yes.
Are you pleading guilty and true freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Stuff you signed, I explained to you.
Yes.
Do you understand those documents that you signed with Mr. Parker?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? So as long as, and the agreement is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And as long as I give you 8 years or less, you cannot change your mind and appeal later. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right. I have to ask everyone that. State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Cogdill is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker and he will present it to me on your behalf when we come back. All right. I'll see you back at sentencing. You can go back with the bailiff.
Thank you.
Miss Holmes, you have a Brianne Williams.
Yes, sure. We may not. Well, you can read yours.
Brianne Williams.
Oh, her. Good morning.
Good morning.
Brianne, it's not, it's contained on here.
Ms. French, this is Brian Williams. It was a TRN and now there's a new thing that's popping up about fees and yes, I love that. Good morning. Are you Brianne Deshawn Williams?
Yes, ma'am. Good morning.
And this is 18-30512. Ms. Williams has a motion to revoke her probation. What is the announcement?
Your Honor, the district attorney's office is showing she has a case received. It's a 2024 offense date, but it's been received. And it appears she had a previous hearing back in 2024, which I think that offense may have been addressed, but it's just now getting to the DA's office to possibly be indicted.
Okay.
Based on the dates, I would agree with Ms. Holmes that the 11/19/24 admin hearing addressed that.
Okay.
But there have been delays with the lab. So I'm not surprised that it's just coming around, but it is received and the state would like to have an opportunity to review that once indicted.
All right, so we'll just do one normal reset. That way, obviously, if there's another case, you can get it all taken care of at the same time. Ms. Holmes will get all of that information from Ms. French and she'll be out there to visit with you, go over what your options are. And then we'll see where we are at that next court date, okay? All right, okay, go back to the bailiff.
Thank you.
I'm gonna wait. Dan Whitsitt. Good morning. Are you Dan Whitsitt?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. Or it's a.
I'm sorry, the
motion.
motion.
Yeah.
Yes, hold on. Let me get that pulled up. Let me get it pulled up real quick. Okay, Mr. Whitsitt, in cause number 24 DCCR 0198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 3-year deferred probation that's been extended for 2 years. Is that correct? The motion alleges you violated your probation. Count 1 alleges that you failed to successfully complete the safety program and the aftercare, and that you were removed from it on December 18th of 2025. And is that true or not true?
It's true.
Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
And then count 3 alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitsitt is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of the third-degree felony offense of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Not real sure. I mean, it's set for sentencing, so I'm very confused about what all that meant.
What are you talking about?
Yeah. And we've had her come every single week. You don't get to just write a letter the day of court and say,
And file it after.
and there's a bug. Yeah, I'm not crazy.
No, I saw it.
Did you see it?
Yeah,
Thank you.
I've seen it.
I know. Right. That Luke pulled up for us that day, right? Yeah. Good morning. You're John Lamel.
Yes, ma'am.
So, Mr. Lamel, I just wanted to visit with you and so we can hopefully get your case moving forward. I know Mr. Adams has had some issues and has been unable to come to court. He filed a motion to withdraw as your attorney. Do you have any objection to that?
I don't know what you're talking about.
He wants to withdraw and not be your attorney.
Yeah.
Are you okay with that?
Yes, ma'am.
Okay.
They wasn't coming.
Right. And so here's what we can do. I can, because you're in custody, I can appoint an attorney today who can start working on your case. Do you want me to do that? Or do you think that you or your family have that money to try to hire someone else?
No, ma'am. You can give me a.
Okay. I will appoint someone today. I will let that attorney know that you've been coming and we've been having some issues and you're just sitting and waiting. And so hopefully they'll get up to speed real quick and we can see what we can get done with your case. Okay.
Thank you so much.
No problem, sir. You can go back with the bailiff. So if you want to print out that order, I'll sign it. I mean, it's a state jail felony MTRP. It's.
You can do it. Somebody else, he wanted to change.
What did I do?
Oh, I don't know, that's you. Okay. It's just strong.
Yeah. On top of the right.
And we think that Mr. Burbank will still be able to maybe come over for that bond hearing. We're just gonna kind of hold it until they're finished with closing argument next door. And so let's see, Mark Phillips, Ms. Holmes.
I'll do the motion and do the data field side.
And I checked the first, allegation, it says an Orange County case. I did check with North County. They said the case has not been filed. They said it's in review.
Okay. All right, so are you Mark Phillips? Mr. Phillips, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Phillips, in clause number 21-36585, I have a motion to revoke your community supervision. Shows that you were placed on probation September 13th of 2021 for the third-degree felony offense of unlawful possession of a firearm by a felon. And that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the new offense of assault family violence in Orange County on October 3rd of 2025. And is that true or not true? Count 2 alleges that you provided a urine sample August 13th, September 10th, and October 13th of 2025 that tested positive for marijuana. Is that true or not true?
True.
Count 3 alleges that you admitted to your Orange County probation officer that you used marijuana on or about August 27th of 2025. Is that true or not true? Count 4 alleges that you provided a urine sample November 6th of 2025 that tested positive for marijuana. And is that true or not true? Count 5 alleges that you admitted to the use of alcohol on August 27th of 2025 to your probation officer. Is that true or not true? And then count 6 alleges that you failed to prove the attendance of AANA meetings as directed by the substance abuse evaluation. Is that true or not true? So did you enter your pleas of true to counts 2, 3, 4, 5, and 6 freely and voluntarily? And because those counts are actually true. All right, then I'm going to find that you entered your pleas of true to counts 2 through 6 freely and voluntarily, find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing, get the probation department to do an updated report that'll give me more information about what's been going on. Maybe get some more information about that count 1, the assault case, if the state intends to bring any evidence with regard to that. Well, I would think an 11 o'clock hearing would be enough.
Should be true.
Okay, so we'll set it at 11 o'clock for a hearing on sentencing. All right, go back with the bailiff.
Again.
Oh, sir, she needs your fingerprint, please. Daniel Pierce.
That's a dismissal, Your Honor. That's all, Your Honor.
Oh, got it. Signing that. He's free to go back.
Dismissal here.
Sorry, I didn't see that earlier, y'all. You've taken him back a while back. Kaylin Thornton.
Into the lesser.
Thank you, ma'am. This is Mr. Coleman's Kaylin Thornton. Good morning, sir. Are you Kaylin Thornton? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
The state's elected to proceed on the lesser included. Instead of the aggravated promotion of prostitution, the state's proceeding on a promotion of prostitution under 4303 of the penal code.
4303
of the penal code. It makes it a third degree as opposed to the first degree that the aggravated promotion of prostitution is.
Thank you. And will he waive the formal reading of the indictment as?
Yes, Your Honor.
All right, so Mr. Thornton, in cause number 26 DCCR 0220, the state's elected to proceed on the lesser included offense of a third degree felony promotion of prostitution from November 15th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, including remaining away from the Northridge Manor Apartments at 4155 Maida Road in Beaumont. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thornton's not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentence. Based on the nature of that plea agreement, Mr. Coleman, what's the state's position with regard to a bond pending or bond reduction pending pre-sentence report?
The defendant shows to be a 25-year-old with no criminal history. However, there are some circumstances related to the underlying offense. I don't know if the court is. There was some violence alleged with regard to the underlying offense. Just for the court's information, we would defer to the court on that, but I just want to make the court fully aware of kind of the.
And Your Honor, we are asking if the court would consider a reduction. Mr. Thornton has no intention of returning to that property. He will.
Where would you be living when you're released, Mr. Thornton?
2118 Avenue B.
That's in Beaumont.
Yes, ma'am.
So what I'm going to do pending sentencing based on the nature of your plea agreement, Mr. Thornton, is reduce your bond in your case to $2,500. If you make that bond, at least pending sentencing, I'm going to order that you wear a GPS monitoring device. That'll make sure that you're following all of the rules. You're not going anywhere near Maida, the apartments, is it Northridge Manor?
Yes, ma'am.
So don't go anywhere near those. And if you do everything you're supposed to between now and sentencing, then I'm not necessarily saying you'll have to wear that while you're on probation or for very long. But if you make that bond while the case is pending, I want to make sure that you're following all of those rules. It's very important if you make that bond, a couple of things, in addition to getting that GPS and staying away from the Northridge apartments. You're going to get some documentation today from probation. If you are released soon, then the very first thing you do is go to probation so they can do that pre-sentence report. If you don't go and don't follow through with those appointments, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand? Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. Okay? All right. You can go back with the bailiff. Daniqua Washington.
She's pleading all counts.
Okay.
Yeah. And I have to make sure they bring her over to Mr. Hill. I'll do that when we finish.
Just a misdemeanor attorney. I can send them that. Prosecutor.
It might be Andrew.
Okay.
Good morning. Are you Shaniqua Diane Washington?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Washington, in cause number 24 DCCR 2370, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 26th of 2025 for the offense of theft of property with previous convictions. And that was a deferred probation for 3 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of failure to identify with intent to give false information on October 4th of 2025. Is that true or not true?
Yes, ma'am.
True or not true?
Yes, true.
Thank you. Count 2 alleges that you failed to report as directed to the probation department in October of 2025. Is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? I'm sorry.
True.
Count 4 alleges that you were at a location other than your residence at approximately 1:23 a.m. October 4th of 2025. Is that true or not true?
True.
Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
Count 6 alleges that you are behind in your court assessed fees. And is that true or not true?
True.
Right. Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you reached with the district attorney that you'll be waiving or giving up any right to appeal? So it looks like the agreement is for me to continue you on probation. There would be a 90-day jail sanction with credit for any time that you've been in custody on the motion, and that I would extend it for 7 months. 7 months is a bit of a random time frame. What's the reason for 7 months? Usually it's,
We worked out 7 months because that's about the amount of time she has missed.
Okay.
Because of inaction or,
Because she was just placed on probation in August.
all right.
so it brings her back to her original sentence.
I think what I would rather do is you go ahead and do the full year. I appreciate Ms. French being generous with that, but I think if you didn't show up, you don't necessarily just get to back where you were. I think there needs to be a little further sanction than time served and getting back where you were. So I understand that's the agreement, but I can extend it's up to me to do that regardless of any agreement. So that is what my intention will be. I'm going to make a notation that
Could be 1 year.
yeah,
Mhm.
extended a year. State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Washington's not competent?
No, Your Honor.
All right, Ms. Washington, you're getting a great opportunity today. I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. But I'm going to follow the agreement with the exception of what I said as far as how long I'm going to extend your probation. I'm going to continue you on probation. I'm extending your probation by 1 year. I'm ordering that you serve 90 days in jail as a sanction. You will only receive credit since you've been in custody on the motion to revoke your probation. I don't know how much you have, but you'll receive credit for that. And then it sounds like you'll go from here, maybe down to misdemeanor court to take care of that other case.
Yes, ma'am.
You did not get off to a good start. I want you to understand that this is your second chance here and that you will not get a third. So if you violate probation again in any way, you're going to be back in here and you'll be looking at being revoked and going to prison. Do you understand?
Yes.
All right. I'm handing you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. All right. Good luck to you, ma'am. You can go back with the bailiff. Thank you, Ms. Fitch.
Yes, I'm gonna check with Mr.
So we're just waiting on Mr. Vasquez and Mr. Burbank. And she's shot.
There's just a president, so. But.
They still have witnesses on? Okay.
You cannot violate any law or ordinance. You must appear in court as directed. No contact at all, no contact at all with the victim in this case. Well, I'm not going to state on record here, but you're not to have any contact at all with the victim in this case. You're not to have any contact with prosecution witnesses. You cannot write, phone, see, text, email, or communicate with the victim or any prosecution witnesses. And you cannot have anybody else do any of those things for you or on your behalf. Your lawyer, of course, has the right to talk to certain individuals, and I'm not going to make that a violation if your lawyer has contact. But other than that, you're not to have any contact. No unsupervised contact, sir. No unsupervised contact with any child less than 18 years of age. 100,000, 10% will be your bond. You're going to have to post $10,000 to secure your release. Your first date will be on, as I said, April the 7th. I wish you well. Any questions, sir?
I don't have $10,000, so do I just sit here, Your Honor?
I'm sorry, I'm not gonna lower that bond. Serious charges. Good luck. Thank you. Thanks, Mr. Shanky.
Your Honor, briefly, go on to that.
Sure. Go off everything, John.
March 11.
Mark 11th, you driving your car. On that date, you have cocaine in your possession in the car. Yes. You did not have authority to have it or prescription, correct? You knew it was there, you knew it was cocaine. Yes. And previous to that, were you in some sort of collision or accident with the vehicle? Yes. And in the process, did you impede traffic? Yes.
You satisfied, counsel? I'm satisfied. All right. I'll dismiss both the original counts 1 and 2. All right. Counsel, on the impeding traffic, fines and costs are $180. Can you pay that today, sir?
Yes. Yes.
All right, pay that before you get out of the building. On the misdemeanor charge, I'm going to send you downstairs to make an appointment with the probation department to come back for an interview. Based on an interview, they're going to put together a report and a recommendation of sentencing. Understood?
Yes.
All right. In the meantime, it looks like you're on a personal bond. I'll continue that bond. Counsel, any questions?
Well, they should set the date.
You go down and have some input on that. All right. Have a good day, gentlemen. Yeah. Morning, counsel. Wonderful.
Give me just 1 second. I was trying to deal with Mr. Taylor, your prisoner. Mr. Taylor has a lot going on and wants another lawyer. Just when I ask him questions.
No, that ain't gonna happen.
Huh?
That ain't gonna happen.
I don't know if you want to pull the radar on.
Put him on here so I can talk to him.
That was, you're here from Mr. Taylor? No, I was here from Mr. Jordan. I'm trying to see what I have to do.
Got that, Joe?
Thank you.
Mr. Taylor, can you hear me all right?
Yes, I can, sir.
Okay, we got a problem. When we pay for the attorney, you don't get to pick them. If you want to pick your attorney, you pay for the attorney. Ms. David Robinson is the attorney that's available today.
Sir, I was just trying to talk to my attorney. I was trying to ask you some questions. I was willing to take responsibility for my actions. She came to me with an offer. I said that I was willing to.
Hold on. Don't get into the facts or the charges at all. You don't want to do that on the record.
Your Honor, this is the issue. Mr. Taylor has some history that I'm not aware of. I'm trying to glean that information because Mr. Taylor wants to know specifically what you could potentially sentence him to. Even though I've explained to him because it is an OWI, there would still have to be a pre-sentence report. He is already on probation, he is concerned whether or not he was doing additional drug jail time.
Right.
He can do a COPS. The issue is I'm trying to get information to come in here and be informed to do the COPS. So he's telling me about his criminal history and it's things that I was not aware of because I wasn't given the information. It's aggravating that I did not know the information. I would not know it if I don't glean it from him.
Right. So, Mr. Taylor, you want another chance to talk to counsel today?
I'm not trying to disrespect your court. I'm like hit or miss with it because
you're not disrespecting my court. Here's the problem.
Yeah.
I'm not saying this is your problem, but I've seen this way too many times. Too often, the defendant tries to run the process.
Nah,
you
it's not that.
The process like this attorney does. Yeah. You gotta let her set the tune, right? You're dancing with it, but you gotta let her lead. Right? So you answer her questions. Then if you get to a point you have some questions, she'll try to answer your. Or you can do it without an attorney. That's your options.
I'm willing. I just want to take responsibility for what I'm going through.
But the way you take responsibility, you should get the advice of counsel before you do that.
Yeah, but I feel like we could have talked about that. She's speaking to you saying this, that, and the third. To me, and with my attorney, I would have thought that she would have knew this information because we just spoke at our arraignment, at my arraignment.
She don't know anything about you other than what she just heard on the file. She knows what your charges are.
But we just had an arraignment, sir. I just got arraigned with this attorney.
Okay, then that is fine. And I did have him on my docket today.
I'm not doing this. I'm not doing this. I'm not doing this. Do you want to start over with this attorney or do you want to proceed without an attorney? Option A.
I want to start over with this attorney. And I apologize, ma'am. I'm not trying to be difficult. It's just like, I'm just trying to get through the process also.
Let her run the process, Mr. Taylor.
All right.
She's the expert.
Okay.
Good luck. We'll put you back in a breakout, Mr. Taylor.
Okay.
Back where? Oh, I don't know. I don't move anybody. You want him in 13? We'll put him in 13.
Thank you.
Miss Knapp, you got anything ready? All right, I got way too many names on this screen for nothing happening.
Not quite yet, Your Honor. I got one more to meet with.
Miss Carter, for the Laramie Judge, LARA. Me?
I'm sorry, you cut out.
Are you ready on Laramie?
Yes, we're ready.
Your appearance.
Good morning, Your Honor. Neighborhood Defender Service by Nurse Ashur, P86643 on behalf of Mr. Laramie.
What are we doing?
We are setting an exam date, Judge. I believe it's already on the
Scheduled for
calendar.
the 31st. Does that work?
Yes, Judge.
All right, 9:30.
Yes.
All right. Anything as to bond?
Just ask the bond will be continued, Judge.
Done.
Thank you. Have a good day.
Mr. Laramie, any questions?
This is gonna be a Zoom meeting, sir, or in person?
No. Preliminary exam is going to be live. March 31 live.
Yes, sir.
My
Okay,
courtroom.
thank you.
All right.
Yes, sir.
Have a
you.
good day.
You too. Thank you very much.
Yeah, well, I'll have the judge call. Okay. Yeah.
Wasn't on Zoom and she didn't show up. Understood?
Yes, sir.
Any questions?
No, sir.
Enjoy your day.
Thank you, sir.
All right, so you can send that one down for next time.
Yeah, kitchens.
File for, all right.
You have the discovery.
March 31 at 9:30 work?
I am not available that day. Would it be possible to move this to the week after? I have discussed the 21-day waiver with Mr. Kitchens and he is okay to waive the 21-day timeline.
3:31.
10:30? No, she's not available 3:30.
Oh, she's not, I'm sorry, 4/7. All we have is noon.
That's us.
That day.
That works.
Noon on April 7th?
Thank you. That's perfect.
Mr. Satchel or Mr. Kitchens, that works for you?
Yes, Your Honor. I'm just going with the lawyer.
All right, say that again?
I said, yes, Your Honor. I'm just going with her.
Okay, all right, so that's gonna be my courtroom live.
Thank you.
Bond will be continued.
All right. Thank you, Your Honor.
Thank you, Your
You're
Honor.
welcome.
Mr. Kitchens, you can go ahead and log off.
All right. Thank you.
Have a great day.
You as well, counsel. Mr. Duncan, how are you today?
Good, Judge. I've got one ready, so I'm reading that one.
What's the name? What's the name, Murray?
It's Obi. Yeah, someone.
GA
Yes.
Yeah, Stevens.
Gagosian.
Yeah.
Yeah. Cousin. Where's your guy at?
He's
on
on,
Zoom.
oh, Florida. Yeah. He's Florida.
Mr. Gagosian, can you hear me all right?
Yes, good morning, Your Honor.
Inch possess.
Hello, Judge Murray Duncan here on behalf of the defendant. I came within the last couple of days, I filed an appearance. I talked to the prosecutor, he's sending me discovery.
Good.
Judge, I'm asking that we set a motion date. This is a 2017 case.
Wow.
There's a couple of issues here that we have to get through.
Okay,
If it's with us, it's April 28th.
that's plenty of time to file something, isn't it? Yeah,
But the only thing is I've got a jury trial here and.
Okay.
Kind of booked it. I'm like, could we go maybe the first or second week of May?
well, I don't know what a couple weeks is gonna matter. I mean, it's pretty old. No, I'm saying a couple more weeks shouldn't matter when it's this old.
The May 5th would be live with.
That's fine.
with us.
Mr. Gagosian, May 5th?
Yes, Your Honor.
Thank you, sir. It is nice meeting you.
Do we want 10?
Good to see you, Mr. Duncan.
Thank you.
11.
11 a.m.?
Yeah, that's fine.
I'll send notice.
All right, Judge, thank you.
You're welcome. All right, go ahead.
Nobody can hear me.
I don't know why that is.
They usually come. You have the volume down? Okay.
I haven't touched that. I turned the volume way up on that one. Yeah. Mr. DiMaggio, can you hear me?
Certainly, Judge.
Are you ready on Williams?
Yes, we're just setting the date for an exam.
All right, we got a number of files here. Let's see what we got.
They always have them on a Tuesday, right?
Bless you. Exam will be on a Tuesday.
Tuesday, yeah. All right.
So basically pick a Tuesday. We'll give you an exam.
All right, I'm checking my schedule thing.
Scratch Jasmine Williams, would you? Williams is here?
She's on Zoom, but we have her in the Zoom room, so we need to do Zoom.
Oh, okay. All right.
Can it be, in April? Be April the 7th? No. Yeah, April the 7th will be.
Can we squeeze another one in?
Or if you could even do it 1 week out, it'd be even better. The 14th.
Say that again?
The 14th of April, that's too far out.
No, it's all right. 9
That'd be
a.m.
great. Yep.
We'll continue bond on that file. We'll send a notice out.
Thank you, Judge.
I got some other files that are in warrant status, counsel. Let's see what we got.
All right.
I've got an April 2019 drove while license suspended. We can set her up for a pretrial on April 16th.
Yeah, but don't you have a misdemeanor house counsel? I'm on the federal, the felony.
Yeah, that's fine. I can just give her the date and she can deal with house counsel.
Yeah, okay.
All right, Miss Williams, you understand that?
No, not really.
Okay, April 19, Romulus Police Department, drove while license suspended, revoked, or denied.
I didn't drive anything in Romulus. April 2019?
Are you Jasmine Denise Williams?
Yes,
Date of birth
it's
11/4/93.
Yeah, are you saying April 19th or April 2019?
April 2019.
Okay, I'm sorry. I have.
That's all right. So we're gonna give you a court date, 9 a.m.
Okay.
And there's also a registration or plate violation. We'll give you the same court date,
Okay, what court date is that? What date is that for?
April 16th,
April 16th, okay.
9 a.m.
Put that in my calendar. April 16th.
Are you working?
Not currently anymore, no.
When's the last time you had a job? Where was that job at?
Last month before I got arrested for this case. And that was at, Nick's Manufacturing in Westland.
Good. All right, I'll put you on a personal bond on these two files. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 on each of those two files for a total of $2,000 if you don't show up April 16th for court?
Yes.
Any questions so far?
No, sir.
All right, you can put your hand down. Currently, you owe us $538. There's a
Okay.
fail to yield ticket, $448, and then we've got two files that you've got a $45 clearance fee on. Are you in a position to commit to some kind of regular payments, weekly,
Yes.
bi-weekly, or monthly?
Yes, I can. I can do a monthly payment.
Yep. How much you want to pay every month and when can you start?
I can do 200 a month starting today.
You sure you can do that much?
Yes.
Okay. Are you gonna come in and do that in person or are you gonna do it online?
Can I do either? Does it matter which one I can do? Because I can do
Doesn't
both.
matter to me.
Okay, I can do either one. As
Oh, I
long
keep
as it gets
forgetting.
done, I don't mind.
Okay. All right. Do you have any questions about everything we've done today?
No,
All right. Good luck.
thank you.
Thank you, Judge.
Yeah,
Take
you
care.
got something ready? You're welcome, counsel.
Yes, judges, top three.
These are all hers.
I'm done.
Let's take care of Miss Fabit on Zoom.
Okay.
Sorry, just have a seat right there.
Hey, where's your, Kirsten?
Counsel, your appearance?
Here, Leslie, yeah, 34696 I'm just going to do that, right? You're going to do this here today, or show causes, Raymond, pre-trial, as far as the show causes, concerned evidence, and you want to 23 call, and the agreement, the way it's.
Thank you. Is Mr. Lecky the prosecutor on this one?
Yeah.
No, I have neither one of them.
Oh, I think you need to call Mr. Galvin. I'm bringing Mohammed.
Yes. Let me send Joe. Hey, Joe. Tell Mohammed I need him online or in here about the Favot matter. Favot, Favot. Well, Steve's supposed to be next door running exams.
Oh. Yeah. Yeah.
You got Pulley online?
Yeah.
Pulley here.
Police are out of mine.
Oh, Mr. Kaplan's here. Mr. Kaplan, were you gonna voir dire a victim on Favot? Go ahead.
Hi.
She's there.
I'm here. Yeah. Well, my name is Steve Galvin. I work at the prosecutor's office. You're the complaining witness in this case, correct?
Yes.
You're the victim. I've heard that you're interested in pursuing this case. Is that correct?
I'm sorry, what was that?
You want to proceed with this case against the defendant?
I want to drop the charges.
What's your name, ma'am?
Kirsten Bernier.
Okay, Ms. Vernier, you do not want to proceed with this case, is that correct?
That's correct.
Has anybody threatened you or offered you any compensation for not testifying?
No.
You realize the case will be dismissed.
Yes.
All right, thank you so much. Thank you, Ernie.
Thank you.
Case dismissed without prejudice. Thank you, ladies.
Thank you. Thank you, Judge Oakley. You have a great day.
You as well.
And the warrant's all cleared?
Yep.
Okay, awesome. You have a good day. Thank you.
All right, Mr. Pulley, can you hear me all right?
Yes, good morning, Judge.
Good morning. Counsel, go ahead.
Good morning. This is a free trial. Oh, Leslie, yeah, 34696 appearing on media for the defendant. Noel Foley, Your Honor, I would have 2 weeks that a final pretrial be scheduled with the complainant to be present.
April 7th? What time?
9:15.
Us?
That is with Judge Martin on Zoom.
I'm already in front of her.
Good. All right. All right, you got that, Mr. Pulley? That's on Zoom, April 7th, 9:15.
Yes, in front of Judge who?
That's Judge Martin.
Okay, yes.
All right, your bond is continued.
All right, thank you, sir.
Mr. Pulley, I think we've already talked about this, but maybe not. You owe us a bunch of money. Are you on some kind of a payment plan on that?
Yeah, we just talked. You put me on a payment plan, so I have to give you 200 by Friday. So
All right. I thought we talked about it already. So you're on track.
Okay.
Okay. All right.
Have a nice day.
Have a nice day. Are you ready on red?
Leslie, yeah, 34696. Very good here for the defendant. The warning is not to waive the formal reading.
Morning. How about the same day, April 7th? Yeah. Another final pretrial. Counsel, let's wait. With the waive formal reading, we should probably do an arraignment.
Did waive formal reading.
All right.
This is 24. The complainant is the mother of my client's ex-boyfriend. I would note that both of them made police reports for whatever reason. Older.
So a no contact order is not going to be a problem.
Well, be a death with no contact and all of 18 months.
All right.
I would ask for.
All right, ma'am, we're going to set you up with a pretrial, final pretrial for April 7th, 9:15. Yes. On Zoom. In the meantime, I'm gonna put you on a personal bond and order no contact. And my paperwork says the complainant on this file's name is Simpson, so you're gonna have no contact with Miss Simpson, no.
That's not.
Okay. Letitia Delane Simpson.
That hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Their examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following. Mr. Gaddy.
Your Honor, we'd acknowledge receipt of the information and waive its reading. We'd stand mute to the charges, ask the court to enter not guilty plea.
Defendant every way formal reading. Standing mute, court will enter a not guilty plea as to all 3 counts. Pre-trial in this matter will be set for
April 7th, 1:30 with Judge Conkey.
April 7th, 2026, 1:30 before Judge Combs.
If I could be heard on bond.
Mr. Bond.
Your Honor, Mr. Evans is a resident of Ann Arbor. He and the complaining witness do not reside together. He rents his own apartment. He has ties to the community. He is gainfully employed. He's not on probation or parole. He does have some holds out of Wayne County. I don't know if they would pick him up on those. They don't appear to be. I'm not able to tell what they. Most of them are traffic. There's one that may be a larceny in building, but it says larceny in building / retail fraud. So I don't know, but they all appear to be misdemeanors. I don't think he would fail to appear to court for court in any way, shape, or form. He would comply with any testing regimen. I would ask for a tether. However, I don't know if they'd put a tether on him until any holds are extinguished.
Jeff, on my end, I did see the two holds Mr. Gary referred to, the retail fraud from Detroit with a bond design, and then a larceny building that didn't have a bond amount set out in Detroit. I would object this time. The victim was present today, and she expressed to us her great fear of the defendant and her fear that he was released. In this case, the victim went to the defendant's apartment and tried to leave, and he told her, "Bitch, no, you're not. You're on the couch." He then told her to sit your ass down, bitch, before I kill you. She was able to use a phone to text a friend to call 911, which they did do. The defendant then took her phone, went to the bathroom. She then ran to try to escape. He wrapped his arms around her neck, pulling her back by the hair and neck, and strangled her to the point of her urinating on herself and telling her, "Bitch, I'll kill you." He eventually stopped and told her she could leave. When she tried to leave, he closed the door and again threatened to kill her. He then grabbed a 2x4, which officers observed holding when they arrived at the residence. So at this point, out of concern for her safety, as well as the community safety, I would check anyone's department.
Anything additional, Mr. Gann?
No, Your Honor. Obviously, we, that's, none of that is in evidence in terms of the actual facts of the case. I would note that the person who she was texting also texted, like, "You're having a hell of a lot of fun." Excuse my language. When I talked to you on the phone a couple minutes ago. But I don't, we're here. He's not a flight risk, and I don't think there's any reason for them to have any contact. And I believe they live quite a ways apart, and I don't think he drives. I believe she lives out in Ipsy and he lives in Ann Arbor.
Oh, given the circumstance, it may not be far enough apart. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
May I have some information?
Yes.
And that was 2 weeks from today's pre-trial? April 7th. Okay, thank you.
The second.
7th.
Yeah. Is that it for you?
Yes, thank you, Your Honor.
Full understanding. Thank you, Your Honor.
May I have it sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Andrew White.
All right. Sir, it is this court's understanding you're going to plead no contest to 3 charges. Is that your understanding?
Yes, sir.
First of all, the count 3 of assault and battery, that's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. You understand that?
Yes, sir.
And also the added counts 4 and 5, attempted resisting and obstructing a police officer. Those are punishable by up to 1 year incarceration, a $1,000 fine plus court cost on each count. You understand that?
Yes, sir.
All right. You understand what a no contest plea is?
I do, sir.
All right. 2 things about it. Have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I do, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
Basis for the no contest plea?
Lack of recall, Your Honor.
Sir, to the charge of assault and battery, how do you plead?
No contest.
To the charge of attempted resisting and obstructing as contained in count 4, how do you plead?
No contest.
To that same charge as contained in count 5, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do, sir.
All right. You signed an advice of rights form, is that correct?
I have.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy of those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of men.
I do, sir.
You understand you're giving up your right to appeal of it.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 25-57770. Any objection to the court having reviewed that report?
None from the people.
None from the defense.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to apprise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the judge would not be bound by any sentence evaluation or recommendation. You understand that?
I understand, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None from the defense.
And have I complied with the quote?
Yes, sir.
And the defense is satisfied.
Court will accept the defendant's plea of no contest to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be May 7th, 2026, 10 a.m. before Judge Washington. Bond with its condition will continue. Thank you, sir.
Thank you, Your Honor.
Yes, it's you. I only got one left. Court does call the case of the people versus Ajax.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Alexandria Taylor on behalf of Nikita Jackson, approaching to my right. Mr. Jackson, please state your name for the record. Nikita Jackson.
Thank you.
Your Honor, this is the day and time set for preliminary examination. The people are ready to proceed. I did have 2 preliminary matters. The court would be willing to address those first.
All right.
First would just be, I don't know if the defendant intends on calling any witnesses. The people have only 2 witnesses that we intend on calling today. I would ask for mutual sequestration to be ordered.
Any objection to that?
Objection.
All right. Witnesses are hereby ordered to question.
Thank you. And the second issue or matter, Your Honors, I would be requesting if the court would permit to turn off the live stream camera that faces the witness box. These are law enforcement officers that often do undercover investigations. And so for their continued safety, I would prefer if we could keep them away from the cameras as much as possible.
Understood.
No objection.
All right. We're going to lock it.
Sir.
Excluded. All right. Very good.
Thank you. People would call Detective Essler and I'll go get him from the side vestibule.
Hold on. What did you say?
Camera on you first.
And then as he walks in, and then we'll fix. All right. Very good. Sir, please come forward and be sworn.
For your executive seat, raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, self you got? I do. State your first and last name, your record, please.
Matthew Kessler, MATT, HO. SS.
All right, you may inquire.
Thank you. Good afternoon, sir. How are you doing?
Good, how are you, sir?
I'm just fine. Sir, how are you employed? In what capacity are you employed?
I'm a detective, science, Michigan State Police, students.
Is that commonly known as LawNet? How long have you been working with LawNet?
I went out there in January of 21, there till October, got pulled back to road for staffing, went back to LawNet in March, April of 23, and been assigned since then.
How many years of law enforcement experience do you have?
I'm in my 16th year with Pittsfield Township, and I served with the city of Ypsilanti for about 2 years previously.
So 18 years total, if I'm doing that math right? Okay. Have you ever investigated drug trafficking or suspected drug trafficking?
Yes.
What sort of investigations or trainings have you done on that issue?
Multiple trainings prior to going to LawNet. I was a road patrol officer and was able to conduct street level kinds of big investigations and into the MSP investigation school. Any other trainings that worked with LawNet.
I want to turn your attention to February 29th of 2024. Were you working on that day? What were you doing that day? What was your title at that time? And specifically on that day, what were you doing that day?
We're surveilling 40 Jackson.
Where were you conducting the surveillance?
We conducted this surveillance in Washington.
At any point, did you ever go to 7573 Roxbury Drive? When did you go to that location? Why did you go there? And just for clarification, do you know what city or township that address is in?
Township, Washington State.
Do you know what sort of address that is? Is that a home, buildings? Do you know who the title owner of that property is, or who owns that property?
Title holder?
Do you know who owns that property? When you arrived at that address, what did you do?
We not announced our presence. Corey had been previously detained, so we president Jackson came into the door.
Do you see Nikita Jackson in the courtroom today? Can you please identify her by an article of clothing that she's wearing?
White blouse and and overcoat.
The record may reflect the witnesses identified the defendant.
Record shall so reflect without objection.
When you first made contact with the defendant, where was she?
She opened the door.
And this sort of building, can you describe sort of the layout of the building?
So when you go in the front door, there were stairs. To the right was a room. To the left was a room. And you kind of went just to the right of the stairs. It took you into the living room / kitchen area.
So there's multiple stories?
It's a 2-story.
Gotcha. What did you do when you made contact with the defendant?
We advised her right here, her son, Cameron, I believe, was coming down the stairs. We asked him to go in the kitchen. Search the house for other occupants. I explained to her while we were there.
Did you ever inform Miss Jackson of her Miranda rights? What did she say when you informed her of her rights?
We then had a conversation.
All right. What was the nature of that conversation?
I called her, she got her arrest, she wanted to go. I told her her Miranda rights. Asked her for drugs and guns in the house. We talked a little bit about her son, Corey, who was the main suspect in this investigation. We talked a little bit about how he had previously stopped over starting this investigation.
Did you ever discuss the resident or who all lived in the house with her, the defendant?
Yes, it was her and her 2 sons.
Did she advise who stayed in which rooms?
She told us which one was Cameron's room, which one was Corey's room, which one was her room.
So which one was the defendant's room?
If you go straight up the stairs, it was just off the left. Was, oh. Sorry.
Yes, Miss Jackson.
If you go up the stairs, you go right, kind of go down that gangway for lack of better words. Then to the right is her master bedroom.
What happened once Lawnet investigators made entrance into the home? What happened next in the investigation?
So once the house was secured, occupants, I stayed in the kitchen, other detectives searched the residence. I spoke to Ms. Jackson. And I was in charge of maintaining the evidence log, collecting the evidence, and putting in evidence bags. And then after that, brought it back to the office.
Were you ever presented any items of evidentiary value by Detective Sergeant McIntosh during this search? What did Detective Sergeant McIntosh provide to you during this investigation?
Provided multiple pieces of evidence by Bill.
And how did you log those items? How do you keep track of them?
So he gives it to people, all detectives bring me. I put it in a evidence bag, evidence log that says what the item is, what room it was found in, where in the room was found it.
And specifically, did you ever have an item number 36?
Yes.
What was that item? And who provided that item to you?
Detective Sergeant.
Did you ever send that item to be tested for anything? Showing defense counsel has been marked as people's proposed exhibit 1. May I approach the witness?
You may.
Sir, name was marked as people's proposed exhibit 1. You can take a look at that. I have a copy for the court's hold.
Yes.
Do you recognize this document?
Yes.
What is it?
It's the lab report from Middleton County Sheriff's Forensic Science Lab.
And looking at this report, is this a fair and accurate copy of the report that you received from that lab as it relates to this investigation?
Yes, sir.
Right. People move to admit what's been marked as people's proposed exhibit 1 into evidence?
Any objection or voir dire?
Objection for exam purposes, Your Honor.
Exhibit 1 is admitted.
So, sir, looking at this document, what on this document shows that this report relates to this defendant?
On the top is the case number and the associated individual.
And you said that you received an item 36 from Detective Sergeant McIntosh, is that correct?
Yes, sir.
Does this document say what that item tested for?
Yes, sir.
What does it test positive, or what did it test for?
GC/MS and GC testing of 1 tablet revealed methamphetamine scheduled to total weight of tablets equals 0.065 grams.
You said 0.065. Are you sure that that's correct?
Unless I'm getting bold, it looks like 0.65, but this is 0.85, right?
I'll move on.
It's like a 6 to 1.
Well, I believe you said 0.065, but it's 0.65. Is that correct?
0.65.
Thank you. So you said that you've investigated narcotics and narcotic trafficking before. Is that correct?
Yes, sir.
Do you know what the typical use amount is for methamphetamine?
I mean, typically there's several pills at a time. People who deal narcotics have thousands of pills. That hundreds of
If I can have just 1 second, please, Your Honor.
Right.
Other than that item that was marked as item number 36, was there any other items of evidentiary value that you recovered as relates to this defendant?
I had to go, but we covered multiple pieces. This was the one that was charged with weapon. We looked in both nightstands. There was tied off baggies of pills, and this was also one that tested as a scheduled narcotic.
How many different pills did you find in the defendant's room?
I think there was probably 5 or 6 baggies. The right nightstand, and there was 4 or 5 baggies of pills, and then the left nightstand where this was located by Sergeant McIntosh. I think it was just this baggie.
Pass the witness at this time.
Cross examination.
Detective Kessler, prior to February 29th, 2024, had you conducted any surveillance of Mr. Curtis? Yes, Roy Curtis. In how many days? And when you were conducting that surveillance, did you put that in your search warrant affidavit?
Yes.
Okay. And your search warrant affidavit largely contains information from the initial stop that you referenced in your prior testimony, but you were not at that initial stop of Mr. Curtis, correct?
Stop that occurred before we executed the search warrant.
That's correct.
I did not stop that. I was part of the surveillance team, but I did not, with Trooper Schreiber on the traffic stop.
Actually, I'm talking about the stop on February 10th, 2024.
That's all. That then stop is what initiated it.
And so the information that's contained in the search warrant affidavit, the first several numbers, where did you get that information? The first several numbers that reference the stop on 2/10/2024. From their report?
Those, I'm not all.
So you
Talking about the paragraphs
in your search warrant affidavit. And so the information contained in those paragraphs from the stop on February 10th, 2024, where did you get the information from that stop?
Wouldn't you have to show him what you're talking about unless he has memory? of it?
That's what you're asking.
Okay, so you reviewed that search warrant affidavit? Or did you say you reviewed their report, Trooper Sass and Trooper McNally?
I authored this.
Did you watch any of the body cam footage from February 10th, 2024? Which footage, if you recall?
We saw. I watched it with Smith.
With Trooper Smith? Were you aware that Mr. Curtis had a valid CPL? If I said that was on the body cam footage, would you have any reason to disbelieve that? And so I know when the prosecutor asked you about what else was found, you said we found guns and ammo, correct? In the residence. Were the guns registered? And so in your experience as a law net officer, usually when you conduct these search warrants and you find guns and ammo, does the defendant typically have a CPL? And right, but you would agree if someone is a convicted felon, they cannot be in possession of a firearm.
By law, they can't.
Yes.
Possession of weapons.
However, that was not the case here, though, correct? None of these weapons came back stolen, correct? And so in an investigation to determine whether there is in fact drug trafficking is whether someone has a CPL, is that relevant information? Okay. So in your search warrant affidavit, you list out again the details from Trooper Sass and Trooper McNeil. Would you agree that that was the foundation of the search warrant affidavit?
Yeah. She did the fire.
And did you later learn that the items that were seized from Mr. Curtis from his vehicle were in fact fake drugs, for lack of a better word? Okay.
32.
And you were gesturing towards the prosecutor, so the prosecutor informed you of that? And is that relevant information to an investigation to determine whether there's drug trafficking? So in your search warrant affidavit, you state that detectives started surveillance of Curtis, and it was yourself, Wiggins, and McCallum in DeCenzo. Did I pronounce that right? Observed Curtis at multiple strip malls. Is that correct? Okay, just sitting in his car. Is that correct? And then you put that on February 21st, 2024, that Detective McCallum observed Curtis at a Shell gas station. Is that correct?
I don't have my search warrant.
Would it refresh your recollection to look at it? Okay. And so is it anything odd about a person being at a gas station in their vehicle?
You see what gas stations, they don't get out and pump gas and they just sit there when they go and just sit in a strip mall and don't go into businesses. That is to be an odd behavior.
And when, let's just talk about like the gas station, did you observe Mr. Curtis exchange any packages with anyone?
Something like you said that, what, the affidavit that was by, so I didn't.
Yes, you didn't observe anything that day. So then again, on February 29th, it stated that Mr. Curtis was parked in front of 1713 Tudor Drive in Ann Arbor. So in your investigations and investigating whether there's drug trafficking, was there anything significant about that address, if you can recall? And had you previously done any investigations regarding that specific address in Ann Arbor? And then again, on 2/29/2024, you reference an address 27227 Winterset Circle in the city of Farmington Hills. Again, that was you that personally observed that, correct? And as part of your investigations, was there anything previously concerning that address in Farmington Hills?
I come to the door, exchange something, then go back in, and then he left. That address was observed shortly before the traffic stop by teenage driver. Is my caution.
And was there anything recovered from that address in Farmington Hills? And so is it fair to say that the addresses that are listed in the search warrant affidavit in the locations such as the strip mall, Tudor Drive, Winterset Circle, these are not Mr. Curtis's home location, correct? And so on February 29th, 2024, when Mr. Curtis was detained, do you know if his vehicle was searched?
That is not certain.
And so in your prior investigations and work with LawNet, has the address of 7573 Roxbury Drive in Ypsilanti Township, has this ever been an address of interest? Okay, all right, thank you.
Can you read her?
No, Your Honor. Thank you.
All right. Thank you, sir. Get it back on. Hang on before you step all the way down. Can you get it back on me? Now it is. Okay. Yeah, that gets. I'll tell you. Thank you, sir. All right, you may call your next witness.
Well, Detective Sergeant Hush.
Just come forward to be sworn.
Senior right hand. Sworn for testimony about the truth, the whole truth, and nothing but the truth, so be it.
Right.
Please spell your first and last name for the record, please.
First name is Christopher Leslie McIntosh, CHRIS, POPHER, MCI, OSC.
All right, you may inquire.
Good afternoon, sir. How are you doing? Doing just fine. Thank you for asking. Sir, how are you employed? In what capacity are you employed? How were you employed back on February 29th of 2024?
Sergeant Law.
How many years of law enforcement experience do you have? Going back to that February 29th date, were you ever at an address of 7573 Roxbury Drive?
Yes.
What were you doing there? And when you made your arrival at that address, what did you do? What was your role in that search warrant investigation?
Primarily the residence was there was search residence.
All right. Did you search the residence? And can you provide the court sort of a layout of what rooms you searched in that residence?
I did a detective sweep of the basement, kitchen, and mainly my focus was in the upstairs bedrooms.
How many bedrooms are upstairs?
I searched 2 bedrooms that were possible. Searched 2.
Which 2, using sort of the layout of the house, what 2 bedrooms did you search?
When you first walk up the stairs, straight ahead was my portrait.
Would that refresh your recollection?
Yes.
Do you have any objection?
No objection.
It's Corey's room, and then to the right, Miss Jackson.
Okay. How did you know which room was Miss Jackson's room?
It is the main room there, the largest room there. It's filled with female items, no, nothing else there. She's also
When you search, and just for the record, do you see Miss Jackson in the room here today?
Right.
Point to an identifier by an article of clothing that she's wearing.
She's sitting to your right, wearing a crown.
The record may reflect this witness that identified the defendant.
Record shows so reflect without objection.
So just making sure I'm understanding. So you said that there's a room belonging to Corey, and then you said there was the defendant's room. Which side was the defendant's room on in comparison to Corey's? All right. And when you go into that room, can you describe the layout of that room? What's in there, or what was in there?
Large bedroom, large bed, both sides nightstand on the other side of the bed. There's a walk-in closet. There's also another closet across from that. And a small bathroom.
When you searched that room, did you discover any items of evidentiary value to your investigation?
I did a nightstand. I discovered a pistol that was sitting there.
Which nightstand? Anything else?
Filled with flat.
Did you present either of those items to Detective Kessler? Which one, if or both?
Both items.
All right.
There were other items I located within the bedroom.
And do you remember what item number the pills were that you gave Detective Kessler?
Probably item number.
No. When you were searching that room, was there any items like an ID or anything belonging to Miss Jackson? What sort of clothing was in the room?
Clothing belonging to.
All right. Were there any, was there a let me rephrase this question. I'll strike that last question. I'll just move on, actually.
Okay.
Other than those 2 items that you previously mentioned, did you find any other pills?
I don't believe I found any other pills. I found other weapons, magazines.
Still in that room or in other places of the house?
In that room, located within the park's room and the bedroom. In the walk-in closet.
How were the pills, the ones that you said were item number 36, how were those packaged?
So they're a plastic bag, you have twist off.
Okay.
So
not in a prescription bottle? What color were those pills? Why did you think they were items of evidentiary value?
pills are normally located, prescription pills are normally located in a prescription bottle. These are located in the plastic. Tend to be illegal.
Just 1 second, please.
Okay.
Pass the witness.
Cross-examination.
Detective McIntosh, prior to executing the search of the home, had you previously surveilled Mr. Curtis
Yes.
that evening? Was that the only time? And do you recall what you observed when you surveilled him? You don't have any recollection of it? Would it refresh your recollection if I showed you the search warrant affidavit? Okay. May I approach, Your Honor?
Only have this one piece of weird.
Detective, did that refresh your recollection? So do you recall on February 29, 2024, observing Mr. Curtis? And so in your training and experience and time that you were with LawNet, that address at Winterset Circle in the city of Farmington Hills, had you ever done any prior investigations there? Is it fair to say that the unknown male that came out of the house, you did not observe him with anything? Okay, thank you. Nothing further.
Correct?
Nothing, Your Honor.
All right. Thank you, sir. You may step down. Right, hold on 1 second. Okay, they got it locked on me. You fine.
Your Honor, we will have no further witnesses and rest at this time.
All right. Any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, people move or bind over on count 1 possession of methamphetamine. I believe the testimony of the court heard today was that search warrant conducted at the defendant's house, and that during the course of that warrant, 2 pills were discovered in the room, in the defendant's room. Those pills tested positive for 0.65 grams of methamphetamine. I believe there's probable cause to believe I believe people have met their burden by probable cause.
Thank you, Your Honor. Your Honor, as this court knows from the previous preliminary examination of Mr. Curtis, those pills that were found on 2/10/2024 were essentially fake. They were not controlled substances. As Detective Kessler testified as the affiant of the search warrant, that stop was largely the foundation of the search warrant. And so, Your Honor, relying on Illinois v. Gates 462 U.S. 213, Your Honor, looking at the totality of the circumstances, there simply was no probable cause. But even if we say
Probable cause to do what?
for the search warrant of the home, Your Honor, because Detective Kessler says that the 210 stop was the foundation of the search that led to the search warrant of the home on Roxbury. But Your Honor, even if the court were inclined to say, okay, despite the pills being fake, they didn't know it, maybe it was, but even looking at this for an affidavit and the testimony from both detectives, there still has to be a nexus. And so the case law requires that there be some nexus. And so the probable cause requirement requires a substantial basis for concluding that the search will cover evidence wrong. So Your Honor may say, like, okay, maybe they have that. However, the judge also requires a fair probability that contraband or evidence of a crime will be found in the particular place searched. And so it's interested in the limited surveillance on these 2 days. It looks like 2/21/2024 and 2/29. Mr. Curtis was essentially everywhere but the Roxbury house. And so how can we say, Judge, that these weak facts can establish a nexus? I mean, that would be a slippery slope. Again, he's at the strip mall, the Shell gas station, Drive in Ann Arbor, Winterset Circle in Farmington Hills. There's absolutely no testimony on this record of any surveilling coming in and out of the house, parked in front of the house, individuals coming. We don't have that, Judge. And so I'm relying on People v. Garvin, which is 235 Mishap 90. It's a 1999 case, Judge. And again, it states it has to be the fair probability that contraband or evidence will be found in that.
Why wouldn't a fair probability be the very fact that he lives?
Because there's no, Your Honor, looking at the case law in cases where they have found that nexus is evidence such as, again, they observe transactions where people are coming to his house and he's walking out and there's a hand-to-hand. Your Honor, everywhere that we have in the search warrant affidavit is outside, and I understand what the court is saying. Yes, he, allegedly he lives there, but there's nothing that ties the house to any sort of criminal activity. And as stated in Garvin, fewer foundational facts are needed to support a search of a motor vehicle. So that I don't disagree with. However, when it comes to a house or a home, the standard is greater. And so based upon, again, these limited interactions that were observed, and even if we think about the
For the cases that you're citing, drug cases?
Garvin is, Your Honor.
Go ahead.
Yes. And so even when I just questioned Detective McIntosh, even with the Farmington Hills one, it's like, yeah, an unknown male comes out the house, but it's like you testified, didn't even see him walking with anything. And so these foundational facts, again, might support a stop of the vehicle, which Mr. Curtis was stopped on 2/29/2024, but it simply fails to meet the requirement, Your Honor, for a search of the home. And so we're asking that this matter not be bound over and it be dismissed.
Sounds.
Your Honor, I want to start off by just drawing the court's attention. I believe there was an argument made that the suspected narcotics originally found in Mr. Curtis's vehicle came back as not be controlled substances. That information was not learned until well after this search warrant was already done and the house was already searched. Certainly at the time that the search warrant was done, the best information they had, and what the information they had was that the defendant's son was trafficking potential narcotics. They drafted a search warrant, the magistrate approved it, they executed that search warrant.
But even if the argument that they're fake drugs is still a crime.
Correct, Your Honor.
So, okay.
Yes. And even if the court said, I think there's an argument to be made, it's not my first leg, I think there's an argument to be made that even if the court says the search warrant wasn't valid, there's still a good faith exception to that for these officers to conduct this search. I did not hear any argument against the elements of this offense being the possession of methamphetamine. And so for reasons originally stated, I would again move this court to bind this case over to stand trial in circuit court.
Anything additional?
Nothing else, Your Honor.
All right. Well, certainly there has to be a nexus, but if I were to buy defendant's argument, that means that where officers may not see the individual go to their address, but know their investigation that the individual resides at that address, that there could never be a search warrant of person's premises. Really, typically, and I have not reviewed, and if you want me to review it, I will, that search warrant, but it leads them at least to that address. There's a nexus. It's important also to understand because this incorporates part of another record. There were not just a couple pills found with the defendant's son. There was a lot of pills. And certainly there may be a reason to ask where are these coming from? Where are you keeping these outside of the trunk of this vehicle? When one is looking at probable cause. It seems to me that the defendant is challenging the search warrant itself, which I would be limited by the four corners of the search warrant. And I don't have a copy of the search warrant. Seems to me that the analysis that this court would go through is in viewing that search warrant, whether or not contained in that search warrant once it's prior to its signing, whether or not there's probable cause to search the premises. And that's where I think you get to the good faith that if on the face of that search warrant, there is good cause or there is probable cause and the search warrant signed, then the execution of that search warrant by the officers and what they discover, I think would be well within their rights, given all of the totality of the circumstances. That it's a good faith exception that they were going through. They were operating on what appeared to them and what was a valid warrant. But I haven't heard the defense argue before the court that the warrant itself is invalid. I don't know that that's what you're arguing to be, because you haven't really said that.
Well, I mean, that is the argument, but I was a little bit in a trick bag today because I discovered that Officer Sass was not going to be here. Because the problem, Judge, is that, you know, Detective Kessler is the affiant, but largely majority of the search warrant is the 210 stop. And so Detective Kessler does not have personal knowledge of that stop outside of what he testified to, that he, you know, reviewed the report. He stated that he reviewed the body cam footage. But again, that was the crux of what the defense wanted to argue, because there are things that are in the search warrant that are contradicted.
Was Sass at the execution of the search warrant?
No, Your Honor, not to my understanding.
Then how does that put you in a trick bag?
Because, Judge, if I'm arguing that the search warrant is invalid, and if 80% of the search warrant is from Trooper Sass, I can't cross-examine.
Well, okay, I get what you're saying, but it's saying that somebody's put it in a trick bag.
No, I didn't mean to imply that it was on purpose. I didn't realize
Okay.
today, you know, when I talked to the people that he said that he was not going to be here, because I just assumed, because again, the basis of the search warrant, and that's why I questioned Detective Kessler about it, is the 210 stop. And so when all the witnesses are here and not one of them was at that stop, it's just difficult because, as I stated, there are things in the search warrant affidavit that are contradicted by the body cam footage, but the body cam footage specifically is Trooper Sass. It's his footage.
Okay, well, if you want, I don't know then. I mean, I'm not going to necessarily frame your argument, but it seems to me that if you're arguing that that the information underlying the search warrant is incorrect, then certainly I would give you an opportunity to, I mean, you can try to get Sass here. The problem becomes somebody else is relying upon that report.
Right.
They place that in a search warrant. I think I'm still then left with, if I view the search warrant and I look at the four corners of the search warrant, if there's probable cause contained within that search warrant, then the officers can act. I mean, I understand where you may want to go, but I don't know.
Right.
I don't.
No, I understand what the court is saying, because the Trooper Sass could testify and the court could still say that based upon the four corners, there were probable cause, or that it was a good faith reliance upon, yes.
Right. And these officers, as I understand it, going back to, I guess, the first part of your argument, they have that report from Sass is what then causes the rest of this to occur. And they believe that based upon that report, they're then observations of the other individual that they need to and would have probable cause to search the residence.
Correct.
So I'm not, I hear you. I'm just not sure how I get there. I'm not sure Sass necessarily helps you. I also don't know that. I mean, like I said, I will review it. I'll review the four corners of the document, but I don't think it gets you to where you want me to be.
I understand.
All right. Okay. So based upon that, hearing the defendant's argument, I don't, at least what's in front of the court now, see anything that is a flaw to the execution of a search warrant, nor which would lead this court to exclude the testimony or exclude the evidence that was seized at that address. The testimony in this case from the two officers indicates that they went into the bedroom, which the defendant herself identified as her bedroom. That evidence was then seized from that location. The methamphetamine was seized from there, logged in, tested, and it comes back methamphetamine. Court believes based on that testimony that people have sustained a burden in showing that there's probable cause to believe that this individual did commit this offense. And so therefore I would bind the defendant over on count one, on single count. As to the arraignment, you
Stand mute and leave a formal reading, Judge.
defendant and wait for a reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
19th at 1:30 with Judge Punky.
May 19th, 2026, 1:30 before Judge Copey. Bond will continue. Thank you.
Any information?
Yes, if we've got one in there, I think we do. Is that it for the day? No, it isn't. I'm in Beth.
Okay, you know who I'm talking about though. All right, so no phone calls, no letters, no social media contact. You see her Burger King, you're eating Taco Bell. She contacts you, says, hey, let's get together for coffee. She can't change the order, only myself or another judge. Clear? All right, raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond? You put your hand down. So that was April 7th, 9:15, Judge Martin, Zoom. Questions?
Nothing, Your Honor, thank you.
We'll get you a notice. Just have a seat.
See, right.
Counsel, you ready on Cleveland? Final. You're Cleveland?
Yes, sir.
Are you going forward without an attorney?
No, put on my attorney.
Okay, who's your attorney?
Phyllis Robinson?
Yeah.
Okay, have a seat. We'll wait for her. We'll wait for her.
Let me see anybody for on this.
What's up?
Any case we recall from Amanda Bonet, or I'm sorry, we recall a Khalil Williams. I've had a victim here for
Sure. Sure. All right, People versus Khalil Williams.
I think it must be hearing of it, people getting towards you.
Yeah, this was scheduled at 9:15. It's now 10:26. Ms. Williams is not present. Bench warrant will issue. I'll make a note in the file that the complaint was here.
You would think that
It's 414. 90. I didn't pay attention. Sorry.
What's the name, Mr. Duncan? Got him right here.
One up Wednesday, thanks.
Thanks.
No,
Your appearance. I just crossed him off.
Yes, sir, I'm Roy Duncan, appearing on behalf of the defendant, Vincent Hightower. Please take a name for the judge.
You have violated the terms of your.
Which was not completed as instructed. The defendant failed to report to probation on multiple occasions, including 8/27 of 2025, 8/28 of 2025, 10/10 of 2025, 11/4 of 2025, and 11/8 of 2025, which ultimately resulted in a warrant being issued on 11/18. General condition number 7, on 7/8 of 2025, the defendant tested positive for alcohol. And special condition number 15D, the defendant did not complete the corrective thinking program, which was approved by the court as a substitute for the previously ordered thinking for change condition.
Mr. Villapendo, do you understand those allegations? You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney? Do you want me to appoint you one? Sure. Okay. Mr. Logs is going to hand you an affidavit of indigency that you need to sign for me, please. You said it was, what was the course he didn't complete?
The corrective thinking.
Thank you. Do you have a jail time credit?
Yes, it is 15 days.
All right, the court will find that you are indigent for the purposes of retaining counsel, and I'll appoint Attorney Alana Van Gundy to represent you in this matter. The court finds that there is probable cause you have violated the terms of your community control, and I'm going to set this for a final hearing, okay? All right, you can go with the deputy.
Hightower.
Thank you.
Judge, for purposes of arraignment, my client will waive the reading and stand mute.
Thank you.
Or I don't strike.
When you want to come back?
Just the court can kind of pick a date on this one. I think I'm gonna give this coverage pretty quick.
I need Tuesday. Everything's gonna be in the meantime.
How about sometime in mid-April?
21st,
Yeah, is that in there?
earlier morning, early or later morning,
Yeah, we can go early, that's it.
8:45.
Sounds good.
If I order no contact, is that going to create any issues?
Yeah, this is-
So I'm going to put you on a personal bond, no contact with Stepchuck, no phone calls, no letters, no social media contact. You see her at Taco Bell, you eat at Burger King. She calls you and says, hey, let's get together for coffee. No. I changed the order, another judge, she doesn't change the order. Clear? What'd you come up with for a date?
April 21st, 8:45.
April 21st, 8:45. Is that Judge Martin or Judge? All right, Mr. Hightower, personal bond, first two conditions are pretty obvious. Stay out of trouble and show up for your court date. Second one is the no contact, or third one is no contact. You can live with those rules?
Yes, sir.
Right hand firmly in the air. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? Any questions? Anything else?
No.
Have a good day, gentlemen.
Your notice is coming right now, Mr. Dollar.
Thank you.
What is this? Gagosian. Counsel, you're on Gagosian? We already did that one.
All right,
Oh, he just brought the paperwork in?
but there's.
Yeah, we don't need that. We don't need that.
Is- Counsel, who do you have, sir?
Porter,
Porter? All right,
what are we doing on it?
Setting exam date, I'm gonna stand for your.
All right, come on up, counsel. You got Mr. Porter with you?
Much too long.
What's that?
Yeah, too long.
Yeah, it has been a while. How you been?
counsel,
Good.
which prosecutor did you deal with so I can make sure they know the date? Because the. Mohammed, okay, thank you.
Counsel, pretty much pick a Tuesday for your exam.
Yeah, let's go. I can do Tuesday, because I have surgery on, April
13th, I'm sorry, Monday, April 13th, and then I'm gonna be out for
Yeah, let's get it out of the way. Good luck. 4/7 at noon?
7 and noon is fine. And I'll make certain that, I don't have anything in them. I'll contact Sport if,
Okay. All right, bond is continued then? All right, have a good day, gentlemen. Sir, we're gonna get you a written notice. We'll get you a notice. Just have a seat.
thanks.
You're welcome, Mr. Son. Or if I forget to tell you on the 7th, good luck on the 13th.
Got it, appreciate it.
Cleveland, we're waiting for Gaten Robinson. Taylor, we're waiting for Gaten Robinson. I pulled the file for
For who?
Patton.
Yes, he's on Zoom. Mr. Duhan is speaking to him now.
I'm here. Mr. Patton wants to waive and be bound over.
Bring him up, break up. Thank you. Yeah, he's up, Judge.
Thank you. Counsel, your appearance for Mr. Patton, please.
Jack Duhan, Neighborhood Defender Service, P number 84871.
Counsel, he has yet to be arraigned. Would you waive formal reading?
Yes, Your Honor.
And
Stand mute.
he wants to waive today?
Yes.
All right, Mr. Patton, can you hear me all right?
I can.
You understand your rights and the options those rights give you?
I do.
You understand the purpose for a preliminary exam?
I do.
Sir, you understand that if you waive the exam, that means your next court date will be at the circuit court level, not at the district court level where I'm at.
I understand.
And are you waiving that exam freely and voluntarily today?
Yes.
Counsel, you satisfied with the waiver?
Yes, Your Honor.
All right. Arraignment on information is going to be next Tuesday at 9 a.m.
Thank you. Judge, can you place a nominal bond on this?
I'm sorry, a what?
Can you put a bond on this case?
Yeah, so we can start gathering some time.
Yes.
Yeah. How about 10,000, 10%?
Yeah, he's gonna be held till July no matter what, so.
Yep. Okay. Mr. Patton, how long you been in custody?
Since November 24.
All right, you owe us a bunch of money on traffic stuff. I'm just gonna close all that out and give you time served.
Thank you.
All right, so that takes care of a bunch of the minor stuff. Your court date on the felony is March 31. Any questions for counsel, sir?
No, Your Honor.
Good luck. Thank you, counsel. Who do you want to start with?
Thank you.
Mr. Taylor, can you hear me all right?
Yes, I can.
All right, go ahead, counsel.
Attorney Phyllis Gaten Robinson, P 71733 on behalf of Mr. Taylor. Mr. Taylor, please state your full name for the record.
Joe Bakari Taylor.
Thank you.
Your Honor, Mr. Taylor, has made an offer to plead to the operating while intoxicated. The other count of
Yeah.
If the children will be dismissed, if I take advantage of that.
All right, so we'll plead to count 2, dismiss count 1. All right. Mr. Taylor, you understand your rights and options?
Yes, sir.
And you understand the possible penalty for the charge, is that correct?
Yes, Your Honor.
Understanding all of that, are you pleading guilty freely and voluntarily to count 2?
I am.
All right, did you drive a vehicle in Romulus on November 24, 2025?
Yes, I did.
Did you consume alcohol before you drove?
Yes, I did.
All right, counsel, do you know what the test results were?
No.
All right. Do you, Mr. Taylor, looking back on it now, do you feel that your ability to operate your vehicle on November 24, 2025 was materially affected due to your consumption of alcohol?
Personally, no, but the law states it was. So, you know, like I said, I want to take full accountability, sir.
Do you know if you took a breath test or a blood test?
I took a breath test.
Do you know what the results were?
No, I do not.
Do you know if it was 0.08 or more?
No, I do not.
Okay, great. You got it? Yeah, hold on a minute. We're going to find out.
Okay.
Leading straight to intox and dismissing. Well, if I did, I misspoke. Are you in custody on this file or something else?
I'm in custody because I missed work program on Friday, sir, and you sentenced me to 6 days in jail.
It's Friday. So why don't you see if you can get Emma on the phone and see if she wants to do another PSI, or if it's fresh enough, we'll just stay going for us and violation all one.
You get something.
Yeah. I'd like to bring him in and be done with it. So not have him come in for a PSI, and
So just see.
so maybe just a little update interview. Just see if you can get a date for him. We're trying to figure out how we can have you come back for one date only on this, Mr. Taylor.
Okay.
Or when he gets out with the 6 days, we'll just give him a date to come back and she can sit down with him and bring him up for sentencing. Whatever she wants. Yeah, whatever she wants to do.
Joel Taylor, he's pleading to his operating tax. Instead of making him come in for free time at the sentencing, are you okay with us just scheduling the sentence date and then have him come in a little bit early and you could just refresh everything since he's already on probation, he was just sentenced in January. You're good with that? So what your sentence? April 23rd, what time do you want him here? 8:30 and then you'll do it real quick. Call 8 o'clock. Yes, okay, I will do the notice. Thanks, bye.
What date is that? April what?
April 23rd. a.m.,
Okay,
So that she can do the interview and then it can be sent out.
okay. All right, Mr. Taylor,
Yes, sir.
still got your address on 4th Street. That's a good mailing?
6th Street, actually. It's 4349 6th Street.
Oh, that's my bad eyes, brother.
Yeah.
Okay, all right, so we'll mail you a notice. The sentencing on this file is going to be April 23rd at 8 a.m.
Okay. I'll be there, sir.
Notice. So I'm just waiting for Miss Gaten Robinson to come in with the information I need to accept your plea.
Okay.
While we're waiting for her, you owe us a lot of money. Are you on some kind of payment plan?
Yeah, and I actually I just paid 200 probably about 2-3 weeks ago, and I told her to put it wherever, but she elected, a clerk lady or whatever in the front desk, she elected to put it towards my probation, but I I do pay my
As
money.
long as you're making regular payments, that keeps us straight.
Yes, sir. Yeah, I made about $200 payment maybe 3 weeks ago, but yeah, 2-3 weeks ago.
Okay. Did you find a number? Okay, based on that stipulation, I can accept. Mr. Taylor, I can accept your plea to the intoxicated driving. I will dismiss count 1, which is the intoxicated driving with occupant under 16. We've got a date scheduled for him. I already told him this. April 23rd at 8 a.m. We're going to mail him a notice. That's sentencing date. Somebody will be here. Somebody will be here. Yeah. Yeah. All right. Any questions on this file, sir?
No, I don't. I'll just wait for that in the mail, and you all have a great day.
Now, on this file, I'm going to put you on a personal bond. 2 conditions. You're in court when you're supposed to be, and you don't purchase, possess, or consume. Understood?
Most definitely. Remember, I have an alcohol tether on as well, so I don't drink alcohol anymore.
Yeah.
Currently.
Belts and suspenders, Mr. Taylor.
Yes, sir.
All right. Good
All
luck.
right.
We'll see you in April.
All right.
We got anybody else at the jail? Counsel, are you ready on Cleveland?
Yes.
All right. Good morning, sir. Counsel, your appearance.
71733, on behalf of Mr. Cleveland. Mr. Cleveland, please take your name to the record.
Cleveland.
All right, so if I'm reading the plea agreement correctly, counts 1 through 4, original counts 1 through 4 are all going to be dismissed. I'm going to take a plea from Mr. Cleveland on impaired driving and no valid operator's license on person.
Yes.
Right? Okay. All right, Mr. Cleveland, did you discuss your rights with counsel?
Yeah.
Did you understand all those rights?
Yes, I
You understand those options?
Yes,
Understanding all of that, are you going to plead to these 2 charges freely and voluntarily? And you understand the possible penalties?
Yes, I do.
All right. Did you drive a vehicle in Romulus on February 19 this year?
Yes, I do.
Did you drive a vehicle while you were suspended, revoked, or denied that day?
Yes.
And prior to driving the vehicle, did you consume some alcohol?
Yes.
Counsel, do you know what the test results were there? Do you know what they were? Yeah, okay. You accept that stipulation?
Yes.
Are you satisfied with the plea? So am I. All right, Mr. Cleveland, I'll dismiss counts 1, 2, 3, and 4. I'm going to refer you downstairs to the probation department, just the counter, the far end of the counter. They'll schedule you to come back for a pre-sentence interview. They'll also tell you when you're going to come back for your sentencing date. Any questions so far? All right. You working? Where do you work? What do they do?
They work as a skills.
Okay.
In that plan.
Okay. How long you been there?
Been there for almost 2 weeks.
Oh, new job. Full time?
Yeah.
Going well? Full time plus. Is it going well?
Yeah.
Good. Good. Good.
Financially stable and take care of myself and my kids.
Good. That's what jobs are supposed to do. Yeah. All right. I'm going to put you on a personal bond on this file. First condition is you stay out of trouble. Second condition is you show up when you're supposed to be in court so we can move this file towards the end. Right. Third thing is do not purchase, possess, or consume any mood altering substance. That means if you don't have a doctor's prescription, you don't do it. No marijuana, no alcohol. Clear? Can you live with those rules?
Yeah, I have alcohol all that.
You do? On this file or something else? He was? Oh, all right.
How long?
All right. When was he arraigned? February?
20.
And we're doing tethers as part of bond now?
It will not be released without alcohol. Yeah, alcohol tether.
Scratch that.
What, get rid of the alcohol tether?
Yeah. We'll give you paperwork so you can go get that taken care of, but you can't drink. All right?
I'm trying to change my life.
I'm gonna help you.
The best I can.
I'm gonna help you. I'm gonna help you. No, I'm serious. I'm not trying to be funny. I put people on probation because I want to change behavior. I don't put people on probation to punish them. I put people in jail, fines of costs, work party. That's punishment. Probation is behavioral change. So we're gonna try to help you change your life. Deal? Good. All right. So raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw up on bond?
Yeah.
He's already got a surety bond? All right. Any questions on any of that?
No, sir.
All right. Put your hand down. All right. Lastly, you owe us money. Are you on a payment plan currently?
No, but.
Can you get on one?
Yes.
Now that you got a new job? All right. All right. So do that before you leave the building. Any questions on any of that?
No, sir.
Go away. Go downstairs, get all set up.
Okay.
You're welcome, Counsel. Okay. Davis?
Yeah.
Toby, come on up.
Good morning, our husband, yeah, 34696, here now we get over the defendant, Toby Davis. Having people waiting to come already.
Thank you.
We're asking that this matter be put over, so I can Probably April 7th would be a perfect date.
All right. Who's that gonna be? Pretrial?
7th is Patton.
That's Zoom then. What time you wanna do it? April 7th, 9:30 in the morning, Zoom? Okay. It's gonna be a Tuesday. And Mr. Davis, you working? Where do you work? How long you been there?
In between jobs, I'm on 2 months in.
Okay. I'm gonna put you on a personal bond. Stay out of trouble, show up for court, don't purchase, possess, or consume any mood altering substance without a doctor's prescription. Can you live with those rules?
Sir, I have.
Okay. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond?
Yes.
Any questions?
No, sir.
You're all set. Have a seat until we get your written notice.
Your Honor,
You're welcome.
I believe, okay, I'll be as soon as I get it.
How we doing out there body wise?
I haven't checked, but I think it was.
I'm all done, unless there's somebody on Zoom that I didn't see.
Check the,
I did, just before.
Sit down. Yep, anywhere. Yep, we'll get your piece of paper in 2 seconds.
I think I'm good.
I think you are too.
Let me just get you in there.
I'll be in Thursday. Oh, Joe, I thought you were a nice guy. Yanking my chain. Yes, the judge to hold you.
What is it, a second?
Sycophant.
Oh, you are? I like, what did you
He's-
say first?
Second.
He's world class. And it sounds, that's classier than saying you're something.
Did you say it's classier than saying you're simple?
It's just, you're a suck up.
Oh. She's simple. I'm sure.
It's really more of those notices for me. You said you did some.
Good idea. The
The notices that come back, yeah. You said you had extra, you gave me some for me. No, I mean, the notice to appear next time.
Oh, yeah, I got a bunch more there.
Where are
Right there, I got one.
they? Oh, okay, cause I'll take. I know, and there's nobody left of to. Doesn't look like that.
Police were before checks up.
You just don't trust me.
Can I get one to your client?
Hey, is Jamie out there?
No, he's not, Judge.
Thanks.
He's upstairs.
Thanks.
Yes, Judge.
Oh, I'm sorry. I dialed the wrong extension.
That's yours. I really don't trust me. I think it I am. Now here's
Security.
Hey, is Jamie around?
Yes. Okay. Yep.
Hey, I've got a meeting with GrowthWorks and City Hall on the 7th, just to touch base, see how things are going. Must be time to renew their lease with the city.
Okay.
Just talk it up down there. If you guys are having any issues with GrowthWorks, just let me know before the 7th.
Okay, April 7th, correct?
Thank you. Yes.
Good.
Yep. How are you? Depends on what you're here for. Exams or next door? Good morning. How are you? I've got a meeting on the 7th with City Hall and GrowthWorks. Just
You didn't know that we knew each other, did you, Miss Sanders?
No, I didn't. I was waiting to do an introduction, but if you already know her, that's even better.
I don't know anything about it. She came in. She said,
I know that you know all, Judge.
Yeah,
it
I
does
do,
not surprise me.
she just said, I'm a new PD. I said, all right. She didn't even give me her name. She just
She didn't even tell you her name. I don't
no.
believe
No, it was sort of rude, but it's okay.
that. Oh,
Felony.
I don't do felon. All right. Court does call the case. People versus David. Is it Wilhelmi?
Wilhelmi, yes.
Sir, say what's your name?
Wilhelmi.
Wilhelmi. All
Yeah,
right.
close.
Sir, you are before the court on a felony complaint that has two charges. All right. The complaint alleges that between the dates of June 27, 2024 and October 3rd, 2024, at the location of 6800 Geddes Road in Superior Township, Washtenaw County, State of Michigan, count one alleges that you did embezzle $50,000 or more, but less than $100,000 or more. Do you understand that nature of that charge of embezzlement, sir?
Yes.
All right. That makes this a misdemeanor, or I'm sorry, a felony, punishable by up to 15 years incarceration, a $25,000 fine, plus court costs. The fine could be increased to 3 times the amount that was embezzled. If that's greater than $25,000, that would become the maximum fine. You understand that, sir?
Yes.
I did say a 2-count, it's actually a 1-count complaint. Sir, the first question I have for you is, do you wish to be represented by an attorney?
Yes. I got it.
Public defender case.
Good afternoon, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Mr. Wilhelmi, we will stand you to the charge, reserve our bond argument, and request a PCC date be set.
Set a preliminary exam or preliminary exam. Probable cause conference in this matter will be set still on the 2nd.
Yes.
April 2nd, 2026, 9 a.m. Esteban, go ahead for the people.
Yeah, people do not object to a PR bond. This matter, we'd ask for a no-go to the Hyundai American Technical Center at 6800 Geddes Road in Ypsilanti.
You said you have no objection to a PR?
That's correct, Your Honor. The defendant has no criminal history.
Got it.
We ask you have no contact with any employees of the Hyundai America Technical Center.
Response.
Thank you, Your Honor. At this time, we'd also be requesting a personal bond. As the people indicated, Mr. Wilhelmi doesn't have any criminal history. This is an older offense dated June of 2024. It wasn't charged until this month. It's a non-assaultive charge. He's the father of a 15-year-old son, and he is currently seeking out employment options, but in the time being, he is doing Uber Eats and door dashing. So he is staying busy. He has no issues with complying with any no contact or no go to order set by Your Honor, as he does reside in Westland. So I believe that will create some distance between him and the old place of employment.
Court will set the defendant's bond in $25,000 cash or $25,000 personal recognizance bond. Other standard conditions, including no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. He is not to have any contact with any employee of Hyundai America. You understand that, sir?
Yes.
In the 6800 Geddes Road address, that is the employment address, Mr. Overwater?
That is my understanding, yes, Your Honor.
Going to indicate you are also not to go to the 6800 Geddes Road address in Superior Township. You understand that, sir?
Yes, I do.
All right. Anything further?
Nothing from the people.
Nothing from the
Thank
defense,
you.
Your Honor. Thank you.
Thank you.
You know, these. Thank you, sir.
Thank you.
Sport. Yeah.
Yeah, they always say. Pretty much. That's something they say.
Right.
Come over here. You wanna go first? You're looping.
Name.
Yeah, man, how you feeling? Oh, man, hangover.
Gotcha.
They did the last one, but you wanna ask him?
Sir, what is your name?
Angel Lupin Contreras?
Did you need a Spanish interpreter?
Nope.
No? Okay. Just wanted to make sure, so that's not the one.
That's how it's flagged. But if he says like.
Okay. He says no, it's good. This is the ring on benchmark. He was previously arraigned.
Yeah.
All right. Court does call the case of the people versus Lupion, or actually it's, they've got this all in here wrong. I think it's, is that how your first name, sir?
Angel?
Yeah, Angel. Okay.
Yeah, it's the same thing, but Angel, yeah.
Angel Lupion Contreras. All right, this is a PD case.
Good afternoon, Your Honor. Assistant Public Defender Alexis Earps with and on behalf of Mr. Lupian Contreras. And it's my understanding this is a failure to appear for a pretrial hearing on the February 18th.
Yes. Is there a reason why you didn't appear, sir?
Yeah, because I
Your
never got
Honor.
a notice, but I understand why I didn't get a notice.
Your Honor, if I may, so one of the bond conditions for his case is not going back to his regular address because the complaining witness also resided there. And at the time he was originally arraigned, he did not know the address of where he was going to be staying. He is currently staying with a friend. He did provide me with that address, so I did give that to the court on the CAA form. So I believe that that issue would hopefully be resolved and he could appear for any future court dates set by Your Honor.
Well, is that the reason he didn't appear?
That is my understanding, Your Honor.
You gotta retrace that for me, Ms. Serves. He's arraigned by the magistrate on 2/10. He's given the date to appear and he doesn't appear. And you say it has something to do with the address?
Your Honor, so he indicated to me he missed hearing the date during the arraignment, and then he was expecting a notice in the mail. And the address the court had on file was for an address that he's not allowed to go to. So I'm assuming the notice went to that address. He did not have where he'd be staying at the time of his original arraignment. I do now have the address of the friend he's staying with, and I did provide that to the court on the CAA form. So I'm assuming mail may have gone to the wrong place.
He couldn't call the public defenders?
Your Honor, we did have a discussion on that's what he should do in the future because it sounds like he may have also not heard any kind of reminders from my office as well.
Oh. Okay. All right. Reset is bound to be happy. What do you have? I have a $5,000 person. Or you said it's bound to a $5,000 personal recognizance bond. I will. The conditions previously set will apply. I'll reset the pretrial in this matter to mine. What day?
April 15th.
April 15th, 2026, 9 a.m. That's before me. Did you hear that date this time, sir?
April 15, 9 a.m.
You got it. Okay, no more excuses.
Yeah.
We'll see you. Thank you.
Thank you, Your Honor.
Ethan. He is, okay, there he is. Got it. Court does call the case of the people versus Orby Huffman. Sir, your name? He's muted.
Orby
All
Huffman.
right. Your name, sir?
Orby Huffman.
All right. Mr. Huffman, you are before the court on a felony complaint that alleges that on or about February 27, 2026, at the location of 2201 Hogback Road, Pittsfield Township, Washtenaw County, State of Michigan, that you did assault a prison employee. Do you understand what you're charged with, sir?
Yes, sir.
That is a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. Do you understand that?
Yeah, I hear you.
All right. Do you wish to be represented by an attorney, sir?
No, I'll represent myself.
Okay. Are you representing, let me just ask you this. Are you representing yourself on the reason why you were there at the jail?
He is not, Your Honor.
Part of the evidence I would like to submit.
Hold on a second, sir. I need you to answer my question. Are you represented by the public defender or someone on the matter which you're in the jail for?
No, I'm representing myself. I've told them I'm going to represent myself.
All right.
Your Honor,
All right.
he's currently represented by Mr. Burgess on that matter.
I got you. All right, sir, I do have to apprise you that there are certain dangers in representing yourself. You understand that, sir? The court is going to hold you by the same standards that the court would hold you to as if you were an attorney. And that includes your knowledge of the Michigan court rules and of court procedure. You understand that, sir?
Yes, sir.
I do have to advise you once again that it is not wise to represent yourself in this matter, but if the offense that you are charged with is a felony punishable by up to 5 years and a $2,500 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right. Do you still wish to represent yourself?
Yes.
Then I'm going to give you a formal arraignment so that you know exactly what the charges are. The complaint alleges that on or about February 27, 2026, at the location of 2201 Hogback Road, that on that day you did, being a person lawfully imprisoned in the Washtenaw County Jail or other place of confinement established by law, did assault Diego Paz, an employee of the place of confinement or a custodian, knowing that person to be an employee or custodian, through the use of violence, threats of violence, or dangerous weapons while awaiting trial. You understand that?
Yes.
And you do understand the maximum penalties that I previously described.
Yes.
All right. I will indicate that you're standing mute to that charge. I will enter a not guilty plea on your behalf. You understand that, sir?
Yes.
All right. I will then set the matter for probable cause conference. April 2nd, 2026, 9 a.m. You understand what you need to do for that proceeding, sir?
Yes.
Anything you want to say regarding bond? I'll hear from the people first.
Your Honor, people would be asking for a cash bond in this matter. Mr. Huffman's currently held on an aggravated stalking charge. That charge, those facts are alleged against his brother. That matter is currently set for trial before Judge Conlon on April 13th. Mr. Burgess is the attorney of record and remains the attorney of record. In this
briefly, the state did file a response on February 22nd of this year. I would just rest on my response, nothing additional. Thank you.
Okay, probation, anything else?
He has 285 days of prison time credit and 38 days of jail time credit, Your Honor.
285 and 38?
Yes, Your Honor.
All right, thank you. Mr. Nelson?
Nothing, we'll stand on our motion.
Mr. Boyd Mayfield, is there anything you'd like to add?
Just first and foremost, I want to thank the court and judge for allowing me to grant judicial release. And personally, I want to thank UT for actually making the choice to send me to corrections, because I wouldn't have got my GED or be able to take the classes that I took while I was there. And basically, I just want to thank you guys for that, allowing me to get released and use those tools and all the lessons I learned in there, be able to apply it to myself on the streets.
Okay. All right, the court today is going to grant your motion. The court is going to find that a sanction other than a term of imprisonment would adequately punish you and protect the public from future criminal activity. You certainly, I believe, my understanding of this offense is an eligible offense, that a sanction other than prison term would not demean the seriousness of the offense, because the factors indicate that your conduct in committing the offense was less serious than other activity constituting an offense. That outweighs those factors indicating their conduct was more serious. So based upon those findings, Mr. Boyd Mayfield, I am going to grant your request and suspend further execution of my prison sentence. I'm going to place you into committee control for a period of 3 years. You'll be ultimately subject to the supervision of the Warren County Probation Department, although the day-to-day supervision will be transferred to your home state of California. You're ordered to refrain from the use of any illegal drugs, alcohol, or marijuana. You are not permitted to use marijuana, okay? I'm going to order you to be held in the Warren County Jail right now until we can get a new assessment or an assessment for you. You're ordered to follow all recommendations of that assessment. The court also finds that you have the future availability to pay the cost of prosecution. So although I'm not going to issue a fine against you, I'm going to assess the court costs against you. If you don't pay those, I can order you to do community service for up to 40 hours per month until you're paid in full, or you make appropriate arrangements to pay that off. The court finds you have 285 days of prison time credit and 38 days of jail time credit. You do have a right to appeal, as does the state of Ohio, of the court's decision today. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Mr. Spitzer, is there anything else, sir?
No, Your Honor. Thank you.
All right, Mr. Nelson?
No, Your Honor, thank you so
Mr. Boyd Mayfield, I am familiar with your record and the activities, obviously intimately knowledgeable of the activities that went on here. I truly hope you've learned your lesson. I want to give you this opportunity to get your life back on track, okay?
Thank you.
Best of luck to you, sir.
All right.
to get out of the tether. And then when he was released, never again was subject to tether monitoring. Your Honor, interestingly, when we look
All right,
at
so
the
what you mean is he went into custody and they took the tether off while he was in custody in Kalamazoo County. Is that correct?
correct.
Okay.
And let him leave Kalamazoo County without putting the tether back on, with the understanding he was going to get the tether put back on, and never did.
All right, well, let me stop you for a minute, just for the record. Did the Kalamazoo County case result in a conviction?
It did not, Your Honor. From lack of participation, they decided to follow the victim's wishes. However, I did notice in my other acts notice, and I did get the video surveillance and body cams that I've shared with defense from Kalamazoo County, and some of the assault of nature that was on video from that domestic violence third charge. That did not result in a conviction.
Okay, go ahead.
Thank you, Your Honor. Notably in the report from pretrial supervision, it says that when he was on the device, there were no violations. However, respectfully, I would think that, you know, the assault of charge would be a violation of bond, which he apparently did while on the tether. So it does not seem that the tether was enough to stop any kind of assault of behavior with significant others. Further, Your Honor, the defendant's history of not only failing to appear, but also his history with drug use and documented convictions for aggravated assault, assault and batteries, attempt, resisting and obstructing, a slew of disturbing the pieces, but more importantly or more troubling, multiple dismissed domestic violence cases, and also 2 that remain a conviction pled down from a strangulation case. As Your Honor is aware, this is a very serious crime, and being on any type of bond and in the community is a privilege with regards to when you are charged with a criminal sexual conduct in the first degree. I believe that this defendant has shown that he is not able to be in the community with any kind of supervision that would protect the public and adequately assure that he is appearing for court. Further, not only was the tether not placed back on, but the pretrial service report indicates multiple attempts of contact were made and no phone calls were returned. He had not been even checking in as required. And then we did get an updated report that said on 3/4 of 2026, he stated he didn't have a working phone and is homeless. It's not setting up ideal situations. If he can't, you know, remain on tether and have the rest of the public safe, I just think it's not appropriate at this point. And we'd ask for his bond to be canceled. Thank you.
Are you referring to the report from our community corrections coordinator, Tiffany Howe? From earlier this month in March, is that correct?
There was one from report dated March 6th of 2026, Your Honor. There was also one dated report January 28th of 2026. I believe I attached the January report as exhibit 2 to my bond motion.
Well, the more recent one you referred to, March 6th,
yes,
is doesn't say who authored it, but Tiffany Howe, where you indicated he did contact the office on Wednesday, March 4th. He does not currently have a working phone and is homeless. He's been staying at the shelter. All right, thank you. That's, I think, in the file as an exhibit. Who's going to speak on behalf of Mr. Benz?
I can make a couple comments, Judge, and then ask Mr. Truckee to maybe play cleanup here. A couple things is the case was dismissed in Kalamazoo. Just yesterday, the day before, I did receive a lot of body cam footage. I didn't have the surveillance footage to review repeatedly throughout the case. And, you know, this is kind of awkward relitigating maybe a domestic violence that was dismissed, but Mr. Ben's very clear. He says he was assaulted first and it was in response to that. Haven't had an opportunity to review that surveillance footage. He did spend 30 days in jail because of that case. Kind of interestingly too, I'd note too that Tiffany Howe does say that the electronic monitoring, I guess there's some attempt to have him placed back on the GPS monitoring. But then at the end of her report, she said it is not considered best practice to maintain an individual on GPS monitoring for an extended period of this length, absent violations or new concerns. I guess maybe that's the violation of the new concern. I don't know. This case has been pending for some time. There was just a 768 notice that we're preparing an objection to file just recently. I would note, and I think this is important because MCR 6.106 is invoked here, that due to the nature of the charges, the court can deny bond if the presumption is great. That's important, Judge, because, and I don't know how much the court is familiar with the case. I assume there's an affidavit.
That's all I do know about it. I didn't handle the case at the district court level. Judge Pattison did, but I have looked at the affidavit of probable cause that accompanies the pleading.
And I would note a couple things in there, Judge. This is a delayed disclosure from 2023 based on allegations in 2015 and 2016. So there are a lot of things going on here. There's a couple protective orders in place. So there are some medical records and some other things I can't really share with the court, but we're litigating those points. So I think what the court would have to find is that the presumption of guilt is great, and then the court would then have to make a finding that the second part of that court rule that either there would be a risk of harm to another individual or the public at large. There was a period of time where Mr. Benz was not making, that he had failed to appear. There have been a litany of status conference, motion hearings, and other things where he has appeared for those things.
I tried to follow the history of this case, and like I said, I'm embarrassed how old this is, but there have been probably more than a dozen court hearings in this matter.
Yeah, that's true, Judge. And underlying all of this too, Judge, is just, well, simple and honest in poverty, right? Where there is someone is living at the homeless shelter, struggling to find secured housing. There have been a long list of phone numbers that have been provided and then been discontinued. So Mr. Benz is here today. He has appeared at numerous court hearings. There is a difference between, there was a bond that was set. Many of the things stated in the bond motion too were known when the bond was set initially. He was able to post that bond, and now the ask, Judge, is to just throw it out altogether and cancel the bond. Court has a wide range of options before it. I think asking to have the bond canceled is somewhat of an extreme ask given the circumstances. So defer to my colleague. Thank you.
All right, Mr. Truckey's quite eloquent. Let's hear from him too.
Thank you, Your Honor. In response to the state's argument, first, there's a hint that bond is a privilege, and I would object to that consideration. Remaining on bond may be a privilege, but it's also a right that our founding fathers established for us. Mr. Benz posted a bond, and he has attended the vast majority of the court dates. There was an issue in November, I believe. Judge Stutzman heard about that at a status conference earlier this year, and he made his determination on that at that time. This domestic violence investigation was also known at that time. A formal motion, I don't believe, was brought before Judge Stutzman, but this was all in the air at the last status conference. It wasn't a big surprise. And Judge Stutzman allowed Mr. Benz to continue on bond. He's been participating in Ministers with Communities in Kalamazoo. That is a resource he's used to stay in contact with me. He's been in regular contact with me. He's not absconded from the state. He's not disappeared. He wants to continue to litigate this case. It's a complex case with old allegations and, again, as Mr. Knopfinger alluded to, very technical and private details that we may be subject to a protective order, but all we're asking is that Mr. Benz continues doing what Mr. Benz is doing while this case is prosecuted. The domestic violence case was dismissed by the prosecutor in that jurisdiction. I don't have documents saying why. I don't have a declination. I don't have a nollie pros order in front of me. The prosecutor in that jurisdiction elected not to pursue charges after Mr. Benz did spend some time behind bars. Of note, the alleged victim in that matter was also taken into custody on that day and released shortly thereafter. She's here today. Also, there's some conflation. There's a criminal sexual conduct charge against a minor, and I don't want the conflation of between domestic violence charges with intimate partners to kind of bleed over. Those crimes, I suppose they rhyme with each other a little bit, but they're not the same. And so I want the court to make sure to kind of consider them distinctly. But with the age of this case, and frankly, with some of the matters going on in the circuit court, there's a concern I have that this may be victim of delay for reasons outside of any of our control. And I would hate to see Mr. Benz spending a prolonged period in custody awaiting his trial. So that's my piece. I'd ask that you deny the motion. If the court would want to impose further conditions, including electronic monitoring, that's understandable. Mr. Benz is employed, so he does have positive people that are in his life as well, besides just the folks at the drop. But we'd ask the court to consider those options short of revoking his bond and taking that extreme step of remanding into custody. Thank you.
Mr. Benz, where are you employed?
Through Open Door Construction.
Which is through the homeless shelter?
No, actually, I went out when I first came to Kalamazoo. I went to a temp service and I met a guy that does construction. He has his own business. Just starting out, I helped build the courthouse in Kalamazoo, and I helped build the Raising Cane on Westmead. He's a commercial contractor. I've been with him. He's actually been with me through this whole thing. I mean, he's been awesome. Been good. Been my boss.
Then why are you in the homeless shelter?
Just because of the traveling. I don't have a car. I can't. My boss picks me up for work every morning, so I'm just trying to get up on my feet, and with the allegations that are put on me, it's kind of hard when they want to run in my background.
If I gave you a drug test right now, this minute, what would it tell me?
Probably great. For weed.
Yeah, for meth?
You said for weed, right?
Just weed. Possibly.
All right.
But I really, that ain't nothing that I have in my.
That's a underlying theme here. Pink elephant in the room. You've been struggling with methamphetamine for a while. Now, this crime allegedly occurred between 2014 and 2016. You've been here multiple times between then and now.
I'm not trying to do anything.
In 2023, I handled file 23653FY, and it was a very unpleasant domestic assault. I believe it was charged as domestic violence. Third offense, it was reduced to a domestic violence, 2 counts. You assaulted your partner, Ms. Yoder, and holding her down on the bed, slapping her repeatedly, tearing her clothes off, shoving her down the exterior steps. I gave you 60 days jail in May of 2023. In 2022 to 2023, the interesting thing is you just got out of jail and filed 23419FY. You were charged with possession of methamphetamine and some motor vehicle offenses. You pled to use of methamphetamine. I gave you a huge gift. 13 days credit, 13 days let you out of jail. You were to pay your fines by August 1st, which you paid 0 of. When it came time to posting a $15,000 bond, you had money. When it came time to paying your court fines and costs, you don't do so good. You have $2,059.32 worth of unpaid fines and costs. That methamphetamine case that I gave you a break on, you paid none. Malicious destruction of a building, $497. Careless use of a snowmobile, I remember that one, $192, and a bunch of traffic stuff. So, all right, I let you out in March. In April, you beat up Miss Yoder and you go to jail for 60 days. In May of 2023, I think you got out sometime in June. Then this case was charged in July of 2023 is when the trooper signed it. So I'm not sure exactly when you got arrested. Although let's take a look at that. I have the bond. So you went to jail in March, you went to jail in April, and then you got arrested on this in July, I think.
The instant case arrest would have been in late November, early December of 2024.
I'm looking for the bond form. I had it. The defendant had failed to appear a couple of times. Frankly, I was surprised that he posted the $15,000 bond. It was set by Magistrate Autumn Kiefer, and the defendant did post it. Then it got revoked, maybe twice. I had the bond. You're not doing better, Mr. Bands. I suspect if I gave you a drug test right now, it would show positive for methamphetamine, and you acknowledge it would be positive for marijuana. You got some indeterminate job and you're living in the homeless shelter. This is not a matter of ensuring that you show up for court. It's a matter of protection of the public.
Just domestic that I had.
All right, well, just your lawyers don't want you to just say things at random. Here's the bond. All right, it was set the amount of $15,000 cash or surety, and it has a number of conditions which are on every bond, and they added some. The conditions of your bond are as follows. These are printed right on the back. Make reports to the court agency as specified by the court or the agency, which would include we don't normally eat or drink while we're in court, so I'd ask you to leave the coffee set aside. We'll pretend like we're in a real hearing. Make reports to a court agency as specified by the court or the agency, which that would include the reporting to community corrections, which right now is off the rails. Not use alcohol or illicitly use any controlled substance. Participate in a substance abuse testing and monitoring program. That was not ordered, but if it was, they ordered 2, 5, 8, and 9. So not use any drugs, comply with the restrictions on personal association of place, residence, or place of employment, not to have any contact with the complaining witness. Condition 8, continue to seek employment. Condition 9, continue to begin educational appointments. The bond also says you shall not harass, intimidate, beat, molest, wound, stalk, or threaten to engage any conduct that would place any of the people in danger, specifically those people. This is the terms and conditions of the community corrections supervision. I will personally appear for any examination, arraignment, trial, or sentencing. Will appear at such times and places as may be directed by the district court or the circuit court. If I am represented by an attorney in this case, any notice to appear may be given by my attorney in place of personal notice to me. I will abide by any judgment entered in this case and will surrender myself to serve any sentence imposed. I will not leave the state of Michigan without permission of the court having jurisdiction over my case if I am on a felony bond. I will not commit any crime while released. I shall immediately notify in writing the court having jurisdiction over my case of any change in my address or telephone number. I will abide by any other conditions described in the face of this form. I understand if I violate conditions 12 or 13, I am subject to arrest without a warrant and may have my bond forfeited or revoked and new conditions of release imposed. Now, the conditions 12 and 13 are not assault, harass, intimidate, beat, molest, wound, or threaten any named person or persons on the face of the bond. And 14 is satisfy any injunctive order. Now, the person that you allegedly molested, beat, or wounded was not a person named in the complaint. But I understand that if I violate any of the terms and conditions of this bond, I will waive extradition if I'm arrested in another state. So you got arrested for a domestic assault. I wasn't clear if the Kalamazoo charge was a felony or a misdemeanor. You do have several previous assault charges here, including the one I gave you 60 days for, which I frankly thought that was a gift. Then just before that, I'd given you 13 days, which was a gift. The statute referred to, or the court rule, which is 6.106, it deals with pretrial release. Now, one of the issues here, this is a serious charge. This is a capital offense, 4 counts of criminal sexual conduct, first degree, which is punishable by up to life imprisonment. It's not breaking into somebody's shed in the backyard. It is a capital offense as a 4th habitual offender. So you take into account the actual nature of the charge. 6.106B (1)B. A defendant charged with criminal sexual conduct in the first degree, which is this, armed robbery or kidnapping, if the court finds that proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person. I don't think you're likely to flee, but I'm not sure I've got clear and convincing evidence that you're not going to be a danger to any other person. Just before you got arrested for this, you seriously beat up your previous girlfriend. And I gave you 60 days in jail. A while later in the same year, you got arrested for this charge. It is true that you have not been convicted of the assault charge in Kalamazoo. To be convicted of that charge, it requires proof beyond a reasonable doubt. And for reasons that probably were apparent to Kalamazoo County, sounds like they had lack of cooperation. They dismissed the case after 30 days in jail. The victim was Catherine Gartner, also known as Catherine Louise Gartner. Is that you?
Yes, sir.
Or you refer to her as your wife. You're not married.
No, no.
All right. She apparently isn't very concerned about it, but what you told the officers was on the body camera, you think I assaulted someone today, just wait till I get out. I'm gonna get out tomorrow on this bullshit charge, and I'm gonna be back on the streets tomorrow, and I got something for your bitch ass. I got something for Catherine when I get out tomorrow. I got something for you, you nigger bitch. I'm not convinced by clear and convincing evidence that you're not a danger to other people. I'm embarrassed that you got arrested for a serious domestic assault charge in Kalamazoo while you've been on bond on this case for 2 years, 3 years here in St. Joseph County. I also haven't made a finding that you're positive for drugs. You've acknowledged marijuana, which is lawful for adults for recreational purposes, but I think marijuana is still in the equation. You also failed to re-register and advise the court of your address after you got out of jail. You're not presently on any tether supervision. We don't know what you're doing. You're not being drug tested, and you're living in a homeless shelter in Kalamazoo. And you talk that way to a police officer in Kalamazoo, threatening him, a complaining witness, and not comporting yourself very well while you're on our bond on a criminal sexual conduct charge. Mr. Benz, I won't be the judge to try this case. I'm not sure who will be. I'm not sure if I'll live long enough to see this case go to trial, but I'm canceling your bond. You're out on a capital offense as a fourth habitual offender. You're not in compliance with your tether requirements. You've got $2,000+ of unpaid fines and costs for previous assaultive and drug offenses here in my court. And you talk like that to the police officers.
I was just angry.
Yes, don't. You're going to jail. Your bond's canceled. A circuit judge can review it for further hearings. And I do apologize because this case is a long way from getting tried.
I would never touch my kid.
All right, well, the fact that you'll never touch any, what did you say, any children? I don't know what you said, but don't say anything else. Take him back into custody. His bond is canceled.
I love you, babe.
Judge Middleton, is this set for trial on April 28th?
Say that again.
This is set for trial on April 28th and is the first case to go.
All right, that's Jill Ross from the circuit court. The matter is set for trial for April 28th. So we are really not talking about that.
Billy, I got you. I love you, sweetheart. Don't worry, Billy. We'll figure it out.
I thought you had sent me an order canceling the bond, but I couldn't find it. Did you do one?
You guys need to let me see it again. Yeah.
We're still on the record, so you guys have a seat for a minute while we finish up, and then you can talk. Did you send an order canceling the bond?
Would you like me to do one, Your Honor? Apologies, I did not.
Well, we had an earlier one. Jill, can you do one?
Yes, I can.
All right. For the reasons stated on the record, the bond is canceled. I feel better knowing there's an April 28th trial date. I don't think he's a flight risk, but I'm not convinced that he's not a danger to other members of the public. All right, thank you. We'll prepare the order here by the court.
Appreciate it, Your Honor. Thank you.
All right, thank you.
Apologies again for the drinking, Your Honor.
Well, you didn't know. People tend to just be informal when they're in their office, and but that's generally not a good form. All right,
Understood.
thank you.
Moving forward.
Nice to
Thank
meet
you.
you. And
Thank you.
good luck as this case goes forward. Thank you, gentlemen.
Thank you, Middleton. You said April 28th was the trial.